Commissioner, the next witness is Mr. Welsh from Westpac.
Commissioner, Mr. Welsh is in the hearing room.
Yes. Now, Mr. Welsh, would you prefer to take an oath or make an affirmation? Thank you. If you'd be good enough to stand while it's administered.
I solemnly and sincerely
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
and
nothing but the truth.
nothing but the truth.
Thank you very much, Mr. Welsh. Do sit down. Yes, Mr. Skovshin.
Mr. Welsh, is your full name Alastair Derek Dawson Welsh?
Yes,
And is your business address Tower 2 International Towers, 200 Barangaroo Avenue, Barangaroo, New South Wales?
yes,
And your current position is General Manager, Commercial Banking?
yes,
Mr. Welsh, have you received a summons to appear at the Commission hearing today?
yes, I have.
Do you have a copy of the summons with you? The original is in court, I understand, if that could be handed up and tendered.
Yes, Exhibit 3.9 will be the summons to Mr. Welsh.
Mr. Welsh, have you also prepared a witness statement in relation to a request for evidence regarding rubric 312?
Yes,
And do you have a copy of the original statement with you?
yes,
And the exhibits?
yes.
And are there any changes that you wish to make to the statement?
No,
Mr. Welsh, is your statement true and correct?
yes,
Attend to that statement, Commissioner.
Exhibit 310 will be witness statement of Mr. Welsh in relation to rubric 3-12.
Thank you, Commissioner.
Yes, thank you, Mr. Skovshin. Yes, Mr. Hodge.
Thank you, Commissioner. Mr. Welsh, you're the General Manager for Commercial Banking in the Westpac Group,
yes,
and you've been in that role since 2011.
yes,
And prior to 2011, you held various roles in the business banking team with the bank,
yes,
and that included being the National Manager for Commercial Business Financial Services from 2003 to 2006.
yes,
And you've also been National Manager of Small to Medium Enterprises in business banking.
yes, that's correct.
Now, you've been put forward by Westpac as its witness for this Royal Commission to respond to the evidence in respect of a guarantee given by Ms Flanagan in 2010 in respect of a business loan.
Yes,
And you've reviewed information relating to Ms Flanagan's case for the purpose of preparing your statement.
yes,
And did you also hear the evidence given by Ms Flanagan?
yes, I did.
And you heard the evidence given by Ms Baglari?
Yes, I did.
And you've come to some conclusions, as I understand it, about whether the case should have been handled better based on your review.
That's correct.
And one of the conclusions you came to was that the case should have been handled better by the request for hardship having been progressed earlier.
That's correct.
And is it only with respect to hardship that you think Westpac ought to have done better in its dealings with Ms Flanagan?
Hardship is the, yes, correct.
All right. And just so we understand the bounds of what we're dealing with, your view is there's not a problem with Westpac having initially accepted a guarantee from Ms Flanagan?
Yes, it's correct that my review of the file shows that we followed the process that I would have want the banker to follow.
All right. Well, I want to just break that down into two elements. The first element is having regard to Ms Flanagan's circumstances, irrespective of what process was followed, is it your view that there's no difficulty or no problem with Westpac accepting a guarantee from Ms Flanagan?
No, that's not correct.
You think there is a problem with Westpac accepting a guarantee from Ms Flanagan?
Sorry, I misunderstood the question. After just seeing Miss Flanagan, it's
No.
pretty confronting, really, isn't it?
I understand. And there's two different issues here. One is, should the bank ever have accepted a guarantee from Ms Flanagan? The second issue is the bank's process in relation to the acceptance of the guarantees, was it adequately applied in this case? Those questions are obviously related. But the first question that I wanted to focus on is just the acceptance, the very fact of accepting a guarantee from Ms Flanagan in this case, irrespective of whether the particular procedural boxes were ticked or not. Is there a problem with Westpac accepting a guarantee from Ms Flanagan?
Technically, there's not a problem.
Right. And then I think that really brings us into the second question, or the second part of this, which is there a problem with Westpac's processes in relation to the taking of the guarantee? And what's your view about that?
No, there wasn't a problem with the technical process of the process.
Right. There wasn't a problem with the application of the process in this case. Is that right?
Thank you, that's correct.
And in your view, is there any issue about whether, if the process was followed in this case, that suggests there's a problem with the process?
Sorry, can you just repeat
Yes.
the question so I'm really clear?
In your view, is there a problem with the formal process that Westpac has for assessing guarantees?
No, there's not.
Okay. All right. I now want to go through that process. You set out in your statement the types of securities that Westpac accepts for business lending facilities,
Yes,
and that would include residential property or cash deposits,
yes,
and it also includes guarantees.
yes,
And Westpac will generally only allow lending of up to $50,000 to a small business to be unsecured.
yes, that's correct.
And otherwise, it would insist on taking some form of security.
Apologies.
That's right. Do you want a moment to do all right?
Sorry, just repeat the question. I was trying
Yes.
to get the order.
For lending above $50,000 to a business, it would insist on taking some form of security.
That's the normal practice, yes.
There's an exception perhaps which we'll come to in a moment, which is in respect of approved franchises. Is that right?
Yes,
And in the absence of general security interest over the business's the business's assets, the bank will seek security over freehold land. Is that right?
yes,
And that can be the business owner's home if that's the only real estate that's available.
yes,
And in 2010, when Ms Flanagan provided her guarantee, Westpac had 2 credit manuals. Is that right?
that's correct.
And you exhibit these to your statement?
Yes, I did.
All right. And I think at paragraph 26 of your statement, you set out the steps involved in assessing a business loan application for a new customer.
And
Have I misled you as to the paragraph number?
number 26,
26.
policies for micro and SME, yes.
And thank you, there we go.
Thank you.
And if we blow up step 2, that's collection of required customer and guarantor information and financials.
Sorry, Mr Hodge, I just,
No,
little
that's right.
embarrassing. Yeah.
It should be on the screen if that would assist you, Mr Welsh.
Yep, that's my general statement that I'm looking at, so that's why I'm a little lost, but I'll correct that problem.
I'm glad it happens to someone else other than me, Mr Welsh, so I wouldn't get too fussed by it.
You've given quite a number of
That'd
statements.
be this one that I'm looking for.
Thank you. I think, but by
Sorry
our count,
about that.
you've given at least 4 statements for this round of hearings, Mr Welsh.
There's
So,
been a few.
yes. You've got to come back a number of times.
I've got it, thank you. Sorry about that, Mr Hodge.
No, that's fine. So if you have a look at paragraph 26 of your statement, which is on page 6 of your statement, this is dealing with the steps involved in assessing a business lending application for a new customer.
Correct.
And step 2 is collection of required customer and guarantor information and financials.
That's correct.
And as I understand it, I'm sorry, we'll just go forward one step first, which is in paragraph 27, you see that it's said after a customer approached Westpac seeking a business loan, a business banker engaged with them to make inquiries about the purpose of the loan, the customer's needs and their financial situation.
Yes.
And is it also the business banker handling the loan who is expected to engage with the guarantor to seek information from the guarantor?
Yes.
Is it expected that the banker would engage directly with the guarantor in order to obtain information about the guarantor's financial position?
Not typically about their financial position.
Is it expected that they'd engage directly with the guarantor at all?
They would engage with the guarantor at the time when they present what we refer to as the bundle of documents, so they have the information, or they could send it to them, but yeah.
I just want to understand some things about the information that might be collected from the guarantor under what's referred to as step 2. Is it expected that the bank manager would understand what the relationship was between the borrower and the guarantor?
Yes.
And is it expected that the bank manager would understand, the business banker would understand about the income of the guarantor?
No, it's not expected.
Is it expected that the business banker would understand or make inquiries about the health of the guarantor?
No, it's not.
Is it expected that the business banker would make inquiries about the assets of the guarantor?
No, it's not.
Right. Presumably, though, when it comes to assets, and we'll see in this particular case, they need to at least know that the guarantor is offering up some asset of security. Is that right?
Yeah, yes, I was referring probably, yes.
You mean in general they don't need to know what all of the assets are of the guarantor, they just need to know
Thank you.
whether they have a specific asset capable of satisfying the bank's debt if the guarantee is called on. Is that right?
Thank you.
Sorry, you were saying, when you
Yes,
say thank you,
yes.
you mean yes. I've
Yes, I mean yes.
summarised Westpac's position.
Somewhat elegant.
And I want to have a look at some parts of Westpac's 2010 credit manual. This is Exhibit 2 to your statement. It's document number WBC.410.001.9483. Very helpful. Hopefully that won't keep happening. But this is something that, it looks like it won't keep happening. This is something that sets out various policies in relation to different issues for a business banker who's assessing a loan or the provision of credit. Is that right?
Yes, this is the start of the policies. Yes,
Okay.
that's correct.
And there's a whole series of policy
Yes.
documents that deal with different aspects of it.
Yes.
All right. And if we go to 9503, page ending 9503,
Thank you.
this is the policy in relation to the Code of Banking Practice. And it explains at the beginning that the code is a voluntary code and sets standards of conduct and procedures to be followed when dealing with individual and small business customers and their guarantors. You see that, Mr. Welsh?
I do.
And Westpac has adopted the code to ensure good banking practice and to protect its public reputation. You see that?
Yes.
All right. And one of the points that it makes, if we go over the page to 9504, not sure why the second page of that policy is redacted. I can't imagine this is going to be an issue, but one of the points that's made, if you have a look on your page, is that Westpac shouldn't treat somebody who is really a guarantor as a co-borrower.
Yeah, yes, that's correct.
And can you just explain what's the difference between, from Westpac's perspective, between a co-borrower and a guarantor?
There's a number of categories of guarantors. I think where we're talking about joint debtors, this is where someone would be implied to be a debtor, and they would give a guarantee in that situation. We don't accept them in that situation.
Okay. And if we go to page .9526, Commissioner, could you just give me one moment? All right, we'll just read out the relevant.
Is there some reason why this is redacted?
Commissioner, I think there is. The answer is at some point in time, I'm being told there's not. My understanding is there were some particular parts that Westpac was informed that we wanted to go to, and therefore the rest of the document has been redacted. Presumably there was an application for non-publication on the basis of commercial in confidence.
Commissioner, an application for a non-publication order was made over certain parts of the manual. The response that we received from the solicitor assisting the Commission was that there were a number of pages that the Commission or the council assisting would take the witness to, and the rest would be redacted, save in respect of a couple of discrete parts.
And what's the position with this page?
No difficulty with the 2 pages that my learned friend just showed me.
Then why are they blacked out on the court book?
That was the response from the solicitor assisting in response to the
Well, it
non-publication
won't take time
application.
to deal with it. It's unfortunate. Yes, go on.
Thank you. Now, Mr. Welsh, if you have a look at 9526, you've got an unredacted copy. You see that there?
Yes, I do.
And this should be part of a document that's explaining the policy of Westpac in relation to lending to a company. If you have a look at the top of the page ending in .9526,
Yes, the top of the page.
and do you see lending to a company at the top?
Yes.
And it's explained that this policy sets out responsibilities and procedures exist to ensure that companies have the necessary authority to borrow/provide security and the transaction provides commercial benefit.
Yes, I do.
All right. And then you see there's then a heading responsibilities, and it sets out what the responsibilities are of certain employees of Westpac.
Yes, I do.
And it sets out the responsibilities for business bankers and credit officers.
Yes.
And you see it says when providing facilities to a company, and it has 4 bullet points.
Yes.
And the first thing that the business banker and credit officer is to do is to consider whether the transaction is in the best interests of the company and other things.
Mm-hmm.
And then the second thing is to know that the people we are dealing with have the authority to commit the company to the transaction. You see that?
Yes, I do.
And then the third bullet point is do not seek a copy of the company constitution.
Yes, I do.
And then if you go over the page to .9527, you see there's a heading company constitutions.
Yes.
And see there it explains that a company may not have its own constitution. It may operate under the replaceable rules. But you see that the third sentence of the first paragraph is Westpac will not seek or obtain a copy of a company's constitution. Instead, it will rely on assumptions it is entitled to rely on when dealing with a company pursuant to the Corporations Act 2001.
Yes, I do.
And then it explains as a note, in all instances where Westpac holds a copy of the company constitution, it will be reviewed to make sure the company has the necessary powers to complete the transaction.
Yes, I do see that.
And goes on to explain where the company constitution might have previously been reviewed, it needs to be checked for any absolute prohibition or unusual restriction on management powers or directors.
Yes, I do see that.
Now, this is the 2010 credit policy. Is it your understanding that this remains Westpac's approach in relation to whether it should or shouldn't seek to obtain a company's constitution where the company is the borrower?
I don't know, actually.
All right.
Sorry about that.
No, that's all right. And do you agree with me, one of the things that might be identified in the company constitution is the circumstances in which the company might pay dividends?
Yes, hypothetically.
Right.
And then if we go to the page .9531, now this is the policy in relation to commercial benefit. Should have at the very top of the page in the top right corner, Mr. Welsh, it'll have WBC.410.001.9531.
Yes, I do see that.
Okay. So this is the policy in relation to commercial benefit that you're having a look at?
Mm-hmm.
Can you see that?
Yes, I can.
All right. And this explains Westpac's approach to the issue of... Sorry, actually, just before I ask about this, can I just clarify, is there any issue with... No, there's no issue with this document. Thank you. With respect to commercial benefit, this is explaining the term that Westpac uses to describe the duty of a director and trustees to act in the best interests of the company or the trust beneficiaries.
Yes.
And it again explains what the responsibilities are of the business banker. Do you see that about a third of the way down the page?
Yes, I do.
And what it's explaining is the responsibility of the business banker in, amongst other things, circumstances in which a company or a trustee is giving a guarantee. So you see it says in the first bullet point, address commercial benefit with all company and trust borrowers and guarantors.
Mm-hmm.
You see that?
Yes, I do.
And the second bullet point is obtain a written statement from the directors of the company or trustees of the trust outlining the commercial benefit to be gained from the proposed transaction.
Yes.
And then there's at the bottom of the page, from the third down, there's a heading which is defining commercial benefit.
Yes.
And you'll see it's explained a benefit will be something of value to the company, or where a trust is involved, something of value to all of the beneficiaries.
Yes.
And it then sets out what might be tangible or intangible benefits that might be derived by a company or trustee.
Yes, I do.
And one of the intangible benefits is an anticipated future flow of dividends from a subsidiary financed by a parent company.
Yes, I do.
And then over the page, it explains what the test is that is applied by a court in relation to directors or trustees, which is in relation to directors, would a reasonable person in the circumstances of the company have given the guarantee having regard to the benefits, if any, to the company?
Yes.
And then just to complete this, you see about halfway down the page, there's then a heading which is commercial benefit and intergroup guarantees.
Yes.
And as you understand it, this policy in relation to commercial benefit to companies and trustees is intended to be followed within Westpac?
Yes, on the circumstances outlined here.
Yes, well, one of those circumstances is where the company or the trust is either a borrower or a guarantor.
Where the company or the trust, yes, I think.
And are you aware of there having been any difficulty that's been raised with Westpac being able to provide finance because of a requirement to obtain a written statement from the directors of the company or trustees outlining the commercial benefit to be gained from the proposed transaction?
Am I aware?
Yes. Has there been any issue, as you've been in charge of the business banking section since 2011, has anybody said it's really obstructing the ability of Westpac to provide credit to certain business borrowers because we have to obtain a statement from the parent company or from a company or trust providing a guarantee?
No, not in the circumstances that we're working through here.
All right. And sorry, when we say the circumstances, or when you say the circumstances we're working through here, is it any circumstances, the only relevant circumstance is that the company or the trust is either borrowing money or providing a guarantee, is that right?
That's my understanding of this sort of intercompany arrangement we're working through here,
All right.
for businesses.
Could you foresee any difficulty if Westpac, where it was taking a guarantee not from a parent company but from a parent, required the parent to provide a statement setting out what commercial benefit the parent was going to get from the loan to the child?
Potentially you could do that. I think might be some difficulties though.
And just explain to the Commissioner what the difficulties would be.
So I think I think your question is, sorry, I'm a little bit confused here, but the policies that we've just worked through here are the sort of intercompany, typically larger companies guaranteeing with a bit more sophistication of financials verifying things. Mm-hmm. And the bridge you're taking me to is, if I've got this right, please, should that be the same for a mum and dad giving a guarantee like a company?
I'm asking, yes, would there be any difficulty with requiring a statement from the guarantor setting out what the commercial benefit would be?
I think there'd be a bit of difficulty.
Okay, and but for the benefit of the Commissioner, what will those difficulties be?
Well, so it is possible. So it would be possible to do something like that, but you'd have to be very clear on what you're looking for. You know, well, the type of financials, would you get tax returns? Would you get their own company? Would you get, you'd have to go through quite a due diligence to do that, which is possible. Just off the top of my head, maybe a challenge with confidentiality as well. You'd also then, once you've got it, you'd have to verify it and work through it and work out whether it was valid and what the thresholds were. So it's possible.
But even the most basic requirement, which would apply if a parent company was trying to give a guarantee of a subsidiary, which is obtain a written statement from the directors of the company outlining the commercial benefit to be gained from the proposed transaction. That's not something that applies if a parent wants to guarantee a child's loan.
Correct.
Right. But you do want parents to be obtaining a commercial benefit or a benefit, however that might be defined, from the loan before they're giving a guarantee.
That is correct.
But you don't require a statement from them explaining what that benefit is.
Well, that's correct.
And is there any particular reason for that?
I can't think of a particular reason. Apologies.
Right. Now, I want to then have a look at Westpac's franchising policy, which is at page WBC.410.001.9628.
9628.
Thank you. That one's not shaded blue, so we can bring that one
We're
up.
both good.
Sorry?
We're both good on that.
Yes. And you'll see this is, as we say, the franchising policy, and as I understand it, it applies if a franchise is part of Westpac's accredited franchise system.
That's correct.
And the particular franchise that Ms. Flanagan was guaranteeing the purchase of, that was a Westpac accredited franchise, is that right?
Yes.
Okay. And Westpac then has a particular policy in relation to lending to borrowers who are seeking to buy into an accredited franchise, and that's this?
Yes. This is this is the policy for the franchisees.
Yes. Well, this borrower that we were concerned with
Agreed.
was seeking to become a franchisee.
Yeah. Yes.
And the way in which the policy works is that it's possible to borrow under the policy based on cash flow of the accredited system rather than having to have real property as security. Is that right?
That is correct.
And of course, the loan in relation to Ms. Flanagan, that wasn't assessed under this policy.
That is correct.
And perhaps you just explain to the Commissioner, what's the reason why it wouldn't have been assessed under this policy and would have instead been assessed under Westpac's general policies?
So the main reason why it wouldn't have qualified for this one is because they wanted to borrow 100% of the value, and there's what we call in here a sector value ratio. We refer to it in good banking terms, SVR, and typically that's a sort of debt capacity. How much can they afford? And it would typically be about sort of 50 to 60%. So given they were 100% borrower, 100% financing this particular Paul Works franchise, that it didn't qualify for the cash flow policy.
I just want to break that down, if we can, a little bit. The showing how well the business operates.
Among other things, yes.
Yes. And Westpac sets a sector value ratio depending upon having made this assessment of what sort of lending is likely to be supported by those types of, just from that sort of business. Is that right?
The debt capacity from that business after the analysis, yes.
Yes. And does that mean, therefore, that if a borrower is borrowing 100% of the value of the business, Westpac wouldn't expect that the business the business taken by itself would be able to support that level of debt?
Yes, that's correct.
Now, I then want to look at Westpac's... I'm sorry.
So just thinking through that, because I don't want to make sure I'm giving misinformation to you.
Yes.
The debt the SVR gives a debt sizing of what's the total business, and the typical situation for that might have been, they look at it and say, you need this bit of equipment, you need this operation. They work out what the sort of value to set it up is, and then we'll lend to a percentage of that if we're going to just rely on a cash flow lending basis with no other security. Yeah. So it's that to unlock the sort of cash flow policy.
Yes, I understand.
Okay, apologies.
And then if we go to tab 5 or exhibit 5 of Mr. Welsh's statement, that should be WBC.410.001.0215. And this is the third-party security guarantees policy?
Yes, it is.
Right. And perhaps if we just immediately jump down to what's described as acceptable third-party relationships. You see that halfway down the page?
Yes, I do.
Right. And there's various relationships that are considered acceptable as third-party guarantees, but the third one is parents guaranteeing a consumer loan for one or more of their children. You see that?
I do.
But this loan that we are concerned with, that Ms. Flanagan was guaranteeing, that wasn't a consumer loan?
That's correct.
And so it doesn't fall within one of the 3 specifically identified bullet points of acceptable third-party relationships?
No, that's not correct.
Sorry, is it referred to somewhere in one of the 3 bullet points?
So I think the line down the bottom is the important one here. This is a sort of if not this, then this. So would you like me to try and explain?
Sure.
So the top ones are tended to be the top 3. So that's directors and shareholders guarantees, and then the spousal guarantee with a single applicant, and then the parent's guaranteeing consumer loan, typically you don't have to verify commercial benefit, and that's read from that last line there that you can see just at the bottom of the page up here. All other guarantee proposals are generally not acceptable unless a direct benefit can be established. So other guarantees are available, but you've got to establish the there's got to be evidence that there's going to be a direct benefit.
All right, and we'll come to direct benefit in a moment, but there's a specific warning that Westpac's policy gave at the time, this is back in 2010, as to parents offering to guarantee the business borrowings of their children. Do you see that?
I do.
And it says, exercise extreme caution where parents are offering to guarantee the business borrowings of their children. Before accepting these types of guarantees, make sure that the guarantor demonstrates that they are making a fully informed decision and that they are fully aware of their potential liability. The account manager and credit officer are to be satisfied that the guarantor has the means, and then in brackets, realisable assets / cash flow, upon which they could rely if called upon to clear the borrower's liabilities to Westpac. I think you're underlining that, you see that there.
I do indeed.
All right. And I take it this warning reflects a concern that Westpac had even at the time about the acceptance of parents guaranteeing the business borrowings of children.
That's correct.
And there continues to be a concern about that, I imagine?
Exercise caution, yes.
And, sorry, what did you say?
Exercise caution, extreme caution.
Extreme caution, that's right. And just so I understand this, is that presumably reflects a concern that there's a risk that parents are going to be taken advantage of? Is that right?
That's one of the risks. That's one of the potential risks.
Yes.
And it's a bit of an assumption, but yes.
And they might not be taken advantage of in the sense that there's any abuse or anything like that, but it's just as a matter of parental love and affection, they will feel like they should guarantee their children's business borrowings.
Well, we heard that today. That can that can happen, obviously.
And the banker will presumably be alive to any signs of vulnerability on the part of the parent?
Yes, they should be.
And what isn't apparent on this policy is what is the process that the account manager and credit officer are to go through to be satisfied that the guarantor has the means upon which they could rely if called upon to clear the borrower's liabilities to Westpac?
The process normally is some evidence of typically an asset, a security of some kind.
I said that. Does that mean what's required is evidence that if Westpac needs to call on the guarantee, the guarantor will be good for it?
Sorry, just repeat the question.
When you say there needs to be evidence of some asset, that means an asset capable of discharging the liability under the guarantee to Westpac.
Yes.
So that the limits of what is in that last sentence, the account manager and credit officer are to be satisfied that the guarantor has the means upon which they could rely if called upon to clear the borrower's liabilities to Westpac. What I suggested to you before was, you're saying all that means is that the account manager and credit officer have to be satisfied that the guarantor will be good for it if Westpac wants to call on the guarantee.
That's how I read that, yes.
And they don't need to be satisfied as to what financial position that would leave the guarantor in if the guarantee was called upon?
That's correct.
All right. And
that the expression realisable assets means realisable by Westpac.
Thank you, yes.
And the policy says before accepting these types of guarantees, make sure that the guarantor demonstrates that they are making a fully informed decision and that they are fully aware of their potential liability. What is the process that the banker is to go through in order to do that?
To make sure they're fully informed?
Yes, making a fully informed decision and that they are fully aware of their potential liability and that they have, I'm sorry, maybe we should break this down.
Mm-hmm.
Make sure that the guarantor demonstrates. Demonstrates to whom?
Make sure that the guarantor demonstrates that they're making a fully informed decision to the banker
Right.
at the first instance.
And so what is the process by which the banker ought to have the guarantor demonstrate that they are making a fully informed decision and that they are fully aware of their potential liability?
They would typically meet with the guarantor. They would make sure that they gave them the appropriate information. So it will be the letter of offer in this case. It would also be the security agreement. It might be the mortgage. Would also look at if there'd been any notices of defaults, and potentially if this was a company that was up and running and already established, there'd also be some historical financials from that company that would be there. So that's the sort of first test that they would be doing.
But it would be expected then that the banker would meet with the guarantor before the guarantor signed the guarantee. Is that right?
That would be the normal practice, where they would meet with them with the information.
And satisfy, that is, the banker would satisfy him or herself at that time that the guarantor is making a fully informed decision
Yes.
and understands and is fully aware of their potential liability.
Yes.
And is that process that the banker needs to meet with the guarantor in order to be satisfied of these things, something that's set out in this policy?
Yeah. Just double checking. So they got the independent legal advice, solicitor certificate, require information concerning the transaction, personally interview. Yes, I think it is.
You think there's, just so we can all see, which is the bit which, in your mind, would set out the process by which the banker needs to meet with the guarantor?
So but can I just explain where I'm reading from? I'll just
Yes.
give a little bit of a little wider. There's two types of guarantors. There's a category A
Yes.
and a category B.
Yes.
So under on 0216 is the start of the explanation around the category B guarantor.
Mm-hmm.
So you can see that they're required to get independent legal advice, required to get a solicitor certificate. They require the consent to provide the information. So, and will personally interview. So that's outlined there.
Yeah, so for a category B guarantor at the bottom of the page, is this the bit you're referring to? Before completing the credit submission, inform the borrower that Westpac?
Mm-hmm.
That's the part you're talking about?
Yes.
And this is about informing the borrower.
The borrower.
But the point you're referring to, I think, is that if we then bring up the following page, what is the fifth bullet point, is that the banker will have to inform the borrower that the Westpac banker will need to personally interview the guarantor,
Yep.
provide a copy of security documents and a copy of the facility letter, and where the Code of Banking Practice applies, other information concerning the borrower's accounts.
Yes.
And therefore, I want to be fair to you, your point is you would expect that as part of that meeting of providing information, that at that meeting the banker would assess and make sure that the guarantor demonstrates that they are making a fully informed decision and they are fully aware of their potential liability.
Yes.
Is that right? I'm
Yes.
not trying to trick you. I just want to make sure I
No, you're not.
correctly
You're doing.
understood your
Yes, that's
evidence.
correct. That's correct.
All right.
Yes, sorry.
And so your point is simply, I think,
Maybe I'm overthinking it, but you've nailed it.
thank you.
Apologies.
And what I'm wondering about then is, and we'll come in further detail tomorrow about the detail of Ms. Flanagan's case, but in your view, were there warning signs that the banker ought to have observed when it came to Ms. Flanagan in interviewing and assessing whether or not Ms. Flanagan demonstrated making a fully informed decision and that she was fully aware of her potential liability?
Yes.
And perhaps if I just identify some, she suffers from, and we could see on the video quite obviously, suffered from quite debilitating health conditions. Would that be a relevant factor?
Yes.
And she had difficulty speaking, could not read and could not write.
Yes.
And her daughter had brought her to the bank.
That's correct.
And if Westpac was to call on the guarantee, she would be rendered homeless.
Yes.
And there might be other factors which we'll come to, but just starting with those four, would you expect that a business banker complying with this policy would at least identify those factors?
Yes.
Would you expect that she would make a note of them?
Yes.
And in your review of the file, have you found any note that the banker made in this case of those factors?
No, I haven't.
And having observed those factors, would you have expected the banker to take any particular course of action?
Yes.
And what would you have expected her to do?
I would have expected her to make sure that Ms. Flanagan had someone appropriate supporting her that was there with her. I would expect that Ms. Flanagan would be read out the information because, as you rightly point out, she's identified that she couldn't read and she had to be read the information. I'd also expect that my banker was really clear that she had to get both independent legal and financial advice. So I'd be wanting to make sure that that was clear. And I'd also want to make sure that the banker was really clear on the limit so she understood. So you'd sort of double down, so to speak, of working through this in a sensible and meaningful way.
Can you play that out a bit more for me? What do you mean by that?
Well, obviously we saw the sad situation that Ms. Flanagan's in today. So you'd expect that any person would be very thoughtful about that and make sure that she was understanding what she was doing and how she would do that would be to sort of take the care and talk her through that and spend time. Now that's not Ms. Flanagan's evidence, which obviously is really disappointing, but that's what you'd hope. I'd also hope that she got support from someone else, as in the external advice. And I probably also think she was pretty nervous at that time, because it might have been the first time, I can't see from the file, that she met Miss Flanagan, and she would have been wary of how much she writes down. She'd be cautious of not wanting to discriminate against her because of a disability. So she'd be sort of alive to that and be really wrestling with that challenge, I'd imagine. Mm-hmm. I think that'd be quite a confronting situation for all parties. Mm. So I think that'd be really, really, really tough. Would have been a tough conversation all round.
Is there any record of the relevant Westpac banker having made a note of her meeting with Ms Flanagan on the 8th of December?
Not that I saw.
So just so we understand, you haven't spoken to the Westpac bank manager, the relevant manager? She's no longer employed by Westpac?
That's correct, and correct too.
You haven't spoken
correct
to her.
on both. I haven't spoken to her, and B, she's not employed.
All right, and so your speculation that she might have felt very nervous and didn't want to write down anything offensive, is that an attempt to explain why there are no notes kept of that meeting?
It's speculation. I don't know that. You're right.
All right. Commissioner, is that a convenient time?
How are we going for time, Mr Hodge?
Well, it's only the first day, Commissioner, so...
No, that's why I'm asking on day one, Mr Hodge.
If tomorrow afternoon I'm offering to start at 9 a.m, say, then, Commissioner, you'll know that you should have pushed me on.
Do I take your lack of answer as indicating that we're travelling perfectly well, Mr Hodge? It's known as a verbal in other circumstances.
At the moment, Commissioner, I have no concerns about getting through the timetable in the way in which we expect
A
to do.
very guarded answer, Mr Hodge. 9:45 tomorrow.
Thank you, Commissioner.
Yes, Mr Hodge, I understand we've got some issue with the screens with the public displays.
That's right, Commissioner. I'm told there's some sort of power outage that has meant the screens have gone down for what the public can see, but the computer system's still working, so the parties and the witness and you can still see the
It's
documents.
unfortunate that we haven't got the public screens up, but I think let's go on for a time and see where we get to. No doubt everybody's running around like a bee in a bottle out the back trying to fix it,
Yes, Commissioner.
but no doubt it'll happen.
Thank you.
Yes,
Thank you.
Mr Welsh.
Mr Welsh, we were speaking yesterday afternoon, I believe, about the third-party security policy that Westpac has. Do you recall that? That's tab 5 of the exhibits to your statement.
Yes.
And we're looking on page 216 at what's to be done in relation to a Category B guarantor.
Yes.
And we looked at some words and some parts of this, but I just wanted to note one further part. You see that one of the instructions to the Westpac bankers under Category B guarantors is do not give predictions, particularly predictions of comfort, that the borrower is able to trade or pay off their debts.
Yes.
And you're aware, or you've read the statutory declaration that was made by Ms Flanagan in 2014 for the FOS dispute.
Yes.
And I want to just take you to that document. It's WBC.407.001.1003. And if we go to page .1004. And you'll see at the top of the page that Ms Flanagan is describing her recollection of what happened at the meeting at the Westpac branch. This is her description 3.5 years ago. And you see in paragraph 14, she says, I said to Michelle is the banker, is that right?
Yes.
I said to Michelle words to the effect of, and I'll leave out the daughter's name, can my daughter cover the loan repayments? Michelle said yes.
Yes, I see that.
And if that had occurred, would that be a prediction of comfort being given by the banker?
Yes, if that had occurred.
And as I understand it, Westpac has no notes of the meeting that happened between the banker and Ms Flanagan on about the 8th of December 2010.
Yes, that's correct.
And Westpac hasn't spoken to the banker about the meeting on 8 December 2010?
Yes, that's correct.
So Westpac has no reason to think this didn't occur?
No, that's not correct.
All right, and what is the reason that you think it didn't occur?
Sorry, I thought you said Westpac has no reason.
That's right, it has no reason to think it didn't occur.
Well, that's Ms Flanagan's statutory declaration.
Yes.
Yet, as you've pointed out, it's clear in the policy. It's also clear in the approach when you sign the guarantee, the information that she reads out. You know, so it's clear. So we obviously have a difference in view.
Well, let's just understand the nature of that difference in view. Westpac has a policy. My question is, can you be certain the policy wasn't breached? And your answer is, we have a policy, therefore it wasn't breached. Is that a fair summary of your evidence?
Yes, you could interpret it that way.
And yesterday, when we were having I was asking you some questions at the beginning, you expressed a view that there was no technical problem with the taking of the guarantee. Do you recall that?
Yes, I do.
And it was remiss of me not to ask you, what do you mean by that? What do you mean there was no technical problem with the taking of the guarantee?
But could I just expand a little here? Would you be okay if I did that?
Yes.
Thank you. This is a little bit of an unusual one because we're focusing on one meeting here. I read the file and looked across the full 4 months. And why I use the words technically when I come back to it is, as you would have seen in early August, the partner signed up for the franchise. In mid-August, the partner produced a business plan. And then in mid-September, there was a business finance request. And in that finance request, there was a note that said that the security would be the house of Ms Flanagan. And then in early October, there was a valuation, which we heard Ms Flanagan acknowledge a valuer came along. Then there was also a cash flow produced that showed the financials, and then we went through a number of steps with our banker and our credit officer asking a few clarifying questions. Then there was the meeting on the 8th, where from the records that I can see, we went through our guarantee, and as I heard Ms Flanagan say yesterday, it was read out to her, which was part of our, which was the requirement and the right thing to do. And then our records also show that that on the 10th of the 12th, she went to an independent lawyer and got independent legal counsel. So when I stand back from that as a banker and look through that 4 months process, it looks a pretty reasonable process to work through just on those facts of those dates. So that's why when you asked me a question of would I have liked to have seen notes of that meeting, I would have liked to have seen notes of that meeting. So that's why I said technically correct.
I'm not sure that really answers the question of technically correct, and we'll come back to that in a moment. What is the document that you're reading from there, Mr. Welsh?
It's just my witness statement. I just put a few notes down this morning to make sure I got the timing right.
Oh, I see.
Scribbled when I got in early here.
I see. All right. And that was what you were reading out to us then?
It's just my run of notes.
All right.
Pretty messy handwriting though.
And well, that's all right. We'll take a copy of that at some stage. Can I then just go back to this question of technical breach? The issue of whether it was technical or not was technical in terms of following the process to obtain a guarantee. You understand that that's the particular process we're talking about. You have a process that you have to go through in order to obtain a guarantee.
Yes, that's correct.
And the question that I asked you yesterday was about whether or not you were satisfied that the process was followed in this case. And was it limited just to the guarantee? Well, perhaps we were at cross purposes. Are you talking about whether there was any problem at all with the loan being made?
Yes, I was referring to across the whole.
All right. So maybe let's break this down into stages. You understand that at the time, under the Code of Banker Practice, it was required that a banker exercise effectively due care and skill of a reasonable banker.
Yes, I do.
All right. And is it the case that you're satisfied in relation to the making of the loan, let's set aside the guarantee, but just the making of the loan, that the requisite level of skill and care was exercised?
Yes, I do.
And the references you just made to the history of the loan application, the business plan, the franchise agreement, the profit and loss statement, those are all things that would have been relevant to the banker in making the decision as to whether she should make the loan in the first place.
Yes, that's correct.
And you've reviewed those documents, is that right?
Yes, I have.
And you've exhibited them to your statement?
Yes.
And having reviewed them and exhibited them to your statement, you've satisfied yourself that it was appropriate to make this loan, is that right?
Yes.
And have you discussed that also with anybody else within Westpac? Has anybody else also reviewed these documents in preparation for you giving evidence to effectively check your view?
Yes.
And who are those people?
I got one of my senior credit people to look through this.
Okay. And that's somebody who reports to you, is that right?
No, not correct.
Oh, I'm sorry, somebody separate from you,
Yes.
and who looked through it and satisfied themselves that it was appropriate to make the loan.
Someone in our credit chain. So that's at what we call our second line. So it's not the first line. So that's the credit chain for SME lending.
Right. And then there's a second stage to this, which is the taking of the guarantee from Ms. Flanagan, and there was a process that Westpac had to go through, required its own bankers to go through before they'd take a guarantee. You agree with that?
Yes, I do.
And you've also reviewed the documents and satisfied yourself that that process was followed in this case?
Yes, I have.
And again, have you spoken to anybody else within Westpac to effectively check that view in preparation for giving evidence?
Yes, I have.
And who are those people?
I also asked our legal team to look at it to make sure it's right, and also the credit team, because this is part of the credit policy, this approach. So,
All right. And I may have misunderstood you then yesterday, because I thought the point you were trying to make was, having seen Ms Flanagan give evidence, you feel some discomfort at Westpac having taken a guarantee from her, but you're satisfied that the technical process had been followed in this case. Was that not the point you were trying to make?
Yes, I felt obviously some discomfort of seeing a elderly person in that situation. Yet, I suppose I went to the technical side, looking across the whole of this, because my view of the situation is we allowed a mother to back her child, and that was part of that's a big part of backing small businesses, where parents support their children, as we heard from Ms Flanagan yesterday, and in this situation it's turned out in a very sad way.
And it follows from that, I take it, that your view is this doesn't point to any problem with Westpac's process, the fact that a guarantee was taken from Ms Flanagan.
It doesn't point to our practice at that point in time of taking the guarantee.
Sorry, it doesn't point to a problem with that practice.
Sorry.
Yes. And has your practice changed since 2010 in relation to taking a guarantee?
A few minor changes.
But nothing in any substantive way that would affect whether or not you took a guarantee from Ms Flanagan?
Correct.
Now, I want to take you then to the documents that you referred to. Perhaps if we start with the loan application, that's at tab 11. Of your documents.
Just before we come to that, Mr Hodges, that stat deck in evidence?
It's already in evidence,
Already in
Commissioner.
evidence,
It's,
thank you.
Exhibit number 1 to Ms Flanagan's
Thank you.
statement. And I think you've got the hard copy, but it's also up on the screen for you,
Thank you.
Mr.
It is.
Welsh.
Yes.
So this is the loan application, and the point that you made about the loan application is that this was signed on the 23rd of September 2010, and we can see that if we go to page 7.0061.
Yes, we can.
And it appears to have been signed by both the daughter and the daughter's partner.
Yes.
And you can see that if you go back to page 5 of the document, .0059. It's identifying who the principal, if we go back to .0059. It's identifying who the principal director is, which is the partner, and the spouse, which is the daughter. You see that there? You should have an unredacted
Yep.
copy with me.
Yes, I do.
And then if we go back to the front page of that document, .0057, you'll see what's said is the business requirement is $165,000 and the own contribution is $5,000. Therefore, the total finance required is $160,000. See that at the top of the page?
Yes, I can.
And having reviewed the documents, what do you understand the $160,000 is for?
For the purchase of 3 Pullworks franchisees.
I see. So this is, as you understood it, the purchase price of the franchises.
And some working capital.
And how much working capital?
Well, in this document it says 8,000.
discuss how much the franchises were actually going to cost?
No, I didn't.
All right, and was that just irrelevant to whether it was appropriate to make the loan?
No, the partner identified that was the cost, and I had no reason to doubt that when you look through the transaction and what was paid.
Right.
So it wasn't. Sorry, this wasn't something I thought to explore that it would be more than that.
I'm not sure we've yet quite got to the root of this. When you say the partner identified that was the cost of what?
Sorry, that was the amount to pay for the right for those franchise areas and some working capital, is my understanding.
$160,000 in total.
Yes.
And when you said working capital, I thought you'd pick that up from this statement here, purpose of finance, where it says $8,000 working capital.
Yes, I did.
Okay, but you had it in your mind before today that this loan was to buy the franchise and to pay for some working capital.
To set up to be able to have the rights to be able to operate the franchise. Yes.
And the total amount for the cost of the rights plus working capital was $160,000.
And a bit of equipment. I think this says 165 minus his own 5,000. So sorry if I'm misinforming you.
No, that's fine. You thought that the purchase price for the 3 franchises plus working capital, the total value of that was $165,000. Is that right?
That is right.
And you see that the other thing that's said here is that it's going to include the purchase of 2 vehicles and stock and equipment. Does that also fall within the $165,000 as you understood it?
Yes, it does.
Did you turn your mind to that before I pointed this out to you now?
I have read it. It wasn't something that I was focused on.
I'm just trying to understand, when Westpac comes to assess a business loan, is it not important to start with understanding what is the loan for with some precision?
It's very important.
All right. And you've looked at it, and your credit manager has looked at it. And can I suggest, sitting here today, having prepared to give evidence at this Royal Commission, you're very vague as to exactly what this $160,000 is going to be used for, aren't you?
Apologies if I'm coming across vague. It's not intended. It's probably normal practice in my experience. You know, I read that quickly. I looked at it and said, $160,000 to buy a pool franchise seems about right. Now you're going to get some equipment, and whether you get the truck and it's in the assets in position. It wasn't my normal practice to sort of labour on that, because you do a reasonableness test to look there, and that's a reasonableness test. So apologies if I'm being vague, but it's not something I spent a lot of time forensically looking at, shall I say.
That's fine, but let's make sure we understood this. So the approach you took to this was you looked at it, and based on your experience with pool franchises, you thought $160,000 sounds like a reasonable price to start a pool franchise.
Oh, I had to inform myself. I'm certainly not an expert on pool franchising.
And how did you inform yourself as to the ordinary price of a pool franchise?
There was, I asked some of the team around what the franchise would have been at that sort of level, because as you'd expect, with not all franchises are equal. Some come with shops and a building and those sorts of things. This was a mobile franchise, and 160,000. And I also looked at the revenue, the forecast there, to sort of get a reasonableness test on that. So I applied a few reasonableness assessments.
I take it when you say that you had to talk to people and attempt to figure it out by looking at the profit and loss, that's because in your review of the documents you couldn't find anything that actually benchmarked the price of this franchise against other franchises. You couldn't find any document from the time that benchmarked the price of this franchise against other franchises.
That's correct.
And you couldn't find any document that actually showed you with specificity how this $160,000 broke down.
That's correct.
All right. And if we go to page .0058, you see at the top of the page, there's a section which is about your business.
Mm-hmm.
And there's two boxes that I want to specifically direct your attention to. One is number of full-time employees, the other is number of part-time employees. You see that?
Yes, I do.
And the number of full-time employees is 0.
Yes, it is.
And the number of part-time employees is also 0.
Yes, it is.
And that's the, as you've noted, this is part of the loan application signed on the 23rd of September 2010.
Yes.
But you were aware of that, weren't you? You made the point to me in the recitation of facts that you'd written down before you came into the hearing room today. You'd noted that there was a franchise agreement signed on the 6th of August, and then there was a loan application made on the 23rd of September. You're conscious of these dates, aren't you?
Yes, I am.
And do you remember when you reviewed these documents having noticed the fact that the loan application said there were no employees?
Yes, I do.
All right. And what did you think of that?
I noted there were some, imperfections, and I suppose I noted it but didn't labour on it, and I'm happy to expand why.
Sure. Expand on it, please.
Often, as a deal is being built up, you start with an application, and then there's a discussion, and you explore it, and the deal moves around. So at the start of a deal from one bit of paper, it's not a pure linear end at the end. That's exactly what happened, because that's exactly the final outcome. Because typically you find that the deal reshapes, and you look at different options, and there are different options they may have talked through. So the deal evolves. So it's not always something that's in the original documents carries all the way through. But lots of things do, but not everything.
I'm not sure I really understand how that's an expansion or explanation of your approach to the fact that the loan application showed there were 0 employees. So let's attempt to just focus on that. You noted there were no employees.
Correct.
And did you think or make any observation as to what that might mean for the deal that was built?
Yes, I did.
And what was that?
Apologies,
Mr. Hodge.
Commissioner.
Thank you, Commissioner. The daughter... I'm sorry, when you referred to the daughter before, it's not the daughter who was working for... Well, the daughter was said to be working for the business. That's one point. Is that right?
That's one point.
And you're noting that this application is inconsistent with other documents that show that the daughter was working for the business? That's the point you're making?
Yes,
And you realise that before you came to give evidence today? You'd observed that inconsistency?
yes,
And you didn't refer to that in your statement?
yes, that's correct.
And it's not just the daughter who was said to be working for the business, was it?
That's correct.
Who else was said to be working for the business in Westpac's documents?
Ms Flanagan,
All right. And you also observed that before you came to give evidence today?
yes, I did.
But you didn't explain that and you note that inconsistency in your statement?
That's correct.
And instead, if we go to paragraph 75 of your statement, on page 16, you said, in respect of Ms Flanagan's status as a guarantor for the loan, the deal build report noted Ms Flanagan as being employed on a part-time basis by the borrower since 30 July 2010. It also noted that Ms Flanagan would be a shareholder of the business and would receive a wage and dividends. That was what you said in your statement.
Correct.
And so I just want to understand, at the time that you prepared this statement, you had already recognised the inconsistency between what was in the loan application and what was in the deal build report?
Yes, I did.
And you knew that a particular reason for saying Ms Flanagan would receive a wage from the business was that that would mean that she had some direct benefit from the business?
In addition to the fact she was was going to be a shareholder and had the right to be able to receive, dividends is what it said.
Yes, but Westpac wouldn't have accepted a guarantee from Ms Flanagan unless she had a direct interest in the business, is that right?
There had to be a commercial benefit.
To Ms Flanagan.
Yes.
And the deal build report identified two commercial benefits. One was, not specifically, this is what you've put out in your statement, one was the wage and the other was the dividend, is that right?
That's correct.
And you, in your statement, noted that the deal build report had said that Ms Flanagan was employed on a part-time basis and was receive a wage. That was one of those direct benefits.
That's what it said, yes.
That's what you said.
Yes. Sorry.
You put in your statement that this is what the deal build report says.
Correct. Yes.
And you knew that the deal build report was inconsistent with the loan application in that respect?
Yes, I did.
And you didn't identify that?
No, I didn't.
And why not?
Commissioner,
Yes.
Mr Welsh's statement was prepared in response to rubric 312. He was not asked to address any deficiency in the loan process. There was a separate request for a general explanation about loan process applications, but not
No doubt
particularly
all
in
this is
relation
so,
to this.
Ms Niskovic. What's the point you want to make?
Because he's being challenged about not putting something in his statement, but he wasn't asked to specifically address this issue.
I think if he wants to give that explanation as to why he did it, then he's free to do that, Commissioner, is my submission.
Yes. Well, you've heard what your counsel have said. Mr Welsh, do you want to take up the life buoy that was thrown to you?
I think I will.
So the reason you left that out was because you hadn't been specifically asked to address it, is that right?
apologies for pausing here, but normally, there are sometimes there are imperfections as the deal goes through, and I've seen a number of those. This is an example of one. I chose not to comment on all of those. On those, sorry.
When you say imperfections, does that mean failures to comply with Westpac's policy?
No, it doesn't.
Does that mean failure to exercise due care and skill as a banker?
No, it doesn't.
Okay. So, if we just go back to the loan application, which is tab 11 WBC.407.001.0057, and if we go to page .0058, and you'll see the security offered for this loan.
Yes, I do.
And the security that was offered for the loan was Ms. Flanagan's home.
Yes, it was.
And so just so we can make sure, for the benefit of the Commissioner, we understand this. If we run through these facts, on the 23rd of September 2010, an application for a business loan is made by the daughter's partner. That's the first fact.
Yes.
At that time, Ms. Flanagan was not employed by the business.
That's correct.
At that time, Ms. Flanagan was not a shareholder of the business.
At that time, correct.
Nevertheless, her property was being offered as security for the business loan.
Yes.
Are those facts just taken by themselves that you expect ought to have caused your banker to be on high alert about why it was that Ms. Flanagan's home was being offered as security?
No.
Notwithstanding that, on the information it's being offered as security, notwithstanding that she has no direct interest in the business.
I'm not sure of the question.
On this loan application, it's quite apparent, if it's read with the company search, which we'll come to, that Ms. Flanagan has no direct interest in the business. Do you agree?
Yes, I do.
And isn't that exactly the situation that Westpac's policy says Westpac ought to exercise extreme caution in?
For the taking of guarantee?
Yes.
Yes, indeed.
And is there anything then that suggests to you that Westpac exercised extreme caution in this case about taking a guarantee?
At which point? Are you asking at this point right here, or?
At any point, is there anything that indicates to you in the documents you have reviewed that Westpac exercised extreme caution in relation to the taking of the guarantee?
Yes, there is.
And what is it?
That at the time of taking the guarantee, we followed our process, included the bundle of documents that we needed to provide to Ms. Flanagan. We completed the checklist of what we read out to her, and we completed the subsequent checklist, and we asked her to get external legal advice, which our evidence showed she did.
All right, so that's, just so I understand, the extreme caution that you've identified is that at the time that Ms. Flanagan was signing up the guarantee, you believe that documents were provided to her?
I do.
And a checklist was completed?
Yes,
and she was told to get independent legal advice.
yes,
And as you understand it, she received independent legal advice.
yes,
All right. And then if we go then to tab 18 of your volume, which is WBC.407.001.0228. And you'll see this is the valuation that was performed on Ms Flanagan's home.
yes,
And it's dated the 5th of October 2010. Do you see that at the bottom of the page?
yes, I do.
And you'll see it was addressed to Ms Fletcher, the Westpac manager or Westpac banker.
Well, again, have we redacted her name?
No, Commissioner.
No, we haven't. Right, okay. Back in my box.
Yeah, yes, I do.
And that must mean that by the 5th of October, Ms Fletcher had instructed Heron Todd, I'm sorry, date, Ms Fletcher had sought to have the property valued.
She did not have that at that point in time. Yes, did not have an interest.
And my question is, that doesn't cause you any concern, is that right?
That's right.
Why not?
Because this is part of the building up of a deal. You see in later notes that's when it, in the submission that she was going to become a shareholder, and she became a shareholder at a later date. These, my experience again in dealing with business, and this is why there's some complexity often in it. There's a number of different things going on at the same time. It's not a linear step by step by step by step. There's a number of things typically happening, and as any deal gets built up.
All right. And so just so that I can make sure that I've understood, the thing that you have latched to is at some point Ms Flanagan was recorded as a shareholder. Is that the thing that is the critical question of whether or not Westpac should or shouldn't have taken this guarantee?
In the submission, she said she was going to be a shareholder.
She didn't say that. Ms Flanagan never said that. Sorry, I just want to be clear about this. When you say in the submission, she said, who do you mean? You don't mean Ms Flanagan, you mean the Westpac banker.
Our banker.
All right. But she didn't say that as at the 5th of October 2010?
Correct.
So the critical thing from your perspective is that because in the future she became a shareholder, there's therefore no concern about what happened at the earlier point in time.
That's correct.
All right. And can we then go to tab 14, which is the business plan? So this is a business plan. You'll see it's dated the 20th of August 2010. You see that,
Yes, I do.
Welsh? And you've reviewed this document before.
Yes, I have.
Commissioner, can I just note, we believe that there was a non-publication direction made with respect to not the whole document, but just the name of the franchise. So it just means that the document hasn't been properly redacted. Now, as it is, the only people who can see the document or ought to be able to see it are you, Commissioner, the witness, and
So
Commission
business
staff.
name trading as something or other.
It's
trade-
if the document's just been taken down. I don't think the document needs to be taken down because it's only for the witnesses. But oh, there we go, it's redacted now. There's a black box. What is behind the black box is the name of the franchise.
Just while we're interrupted, at 11 o'clock I'm going to adjourn so that a tech can come and look at the feed to the screens, see if we can get the public screens back up at 11. So can you order your affairs, council order their affairs on the footing that at 11 I'll adjourn.
Thank you, Commissioner. So this is the business plan dated the 20th of August 2010. Mr. Welsh?
Yes, it is.
And you see it's redacted on the screen, but you've got the unredacted copy, I hope, in front of you, which has trading as and the name of the franchise and then the name of the franchise area. You can
Yes.
see that there. All right. And then if you go over the page, again, we might bring that down and we'll just do it off the documents that you and I have. So at the top, it identifies the name of a different franchise area. You see that?
Yes.
And you can see that also if you look over to the subsequent page, that it's also a different franchise area.
Yes.
And if you also look on page ending .9172, which is the second page of the document, you'll see the description, and I'll substitute the names. Partner is responsible for general management, business development and service manager, while daughter manages the administration and accounts. We are currently looking to employ an on-road pool technician, and we'll be looking to appoint a shop manager when we reopen the retail hub in the near future. You see that there?
Yes.
And there's no reference to Ms Flanagan being employed there, is there?
That's correct.
And then if we go over to page .9175, which sets out the business structure and staff, and you'll see it identifies the partner as the franchisee, the partner as the service manager, a vacancy for the store manager, the daughter as the finance and admin officer, and a vacancy for the service technician.
Yes, I do.
And there's no reference to Ms Flanagan being an employee.
That's correct.
And can I suggest in your review of the documents, you've seen nothing except the deal build notes by the banker to suggest that Ms Flanagan was an employee of the business?
That's correct.
And all of the primary documents show something contrary to that, which is that Ms Flanagan was not an employee of the business? The loan application shows there were no employees of the business. Do you agree?
Yes, I do.
This business plan records 2 employees and 2 vacancies, none of which are relevant to Ms Flanagan.
That is correct.
And does that inconsistency raise for you any concern about the process by which Westpac went about building this deal?
No, it doesn't.
Can we go then to the franchise agreement, which is tab 15? I suspect that's being redacted in real time, but you'll see, I want to point out a few details to you, which are, you see at the top of the page, this has a fax header, or part of a fax header.
Just which page do you want me
I'm
to-
sorry, on page .9118, the top of the page in your exhibit 15.
Yes, I do see that.
And so this document, the franchise agreement, appears to have been faxed as part of a larger document.
Help me out. How you're reading that?
You see it's page 14-/33 in the top right corner.
I do see that. Yes, thank you. Sorry.
So it appears as if this was faxed as part of a 33-page document on the 19th of October 2010.
On that evidence, yes.
And can I suggest, and I'll come back to why I suggest this in a moment, that what appears to be happening is that the relevant Westpac branch is faxing this to some part of the credit assessment team. Does that sound right?
No, I don't know who it's going to.
You don't know. That's fine.
So,
In any event, this is, when you referred before to the franchise agreement that you looked at, that is this document, is that right?
yes, it is.
All right, and so what we've got then is the front cover of the document,
Yes.
and then if you turn over the page, which you'll see is page 15 of 33 on the fax header, so we haven't lost any pages in between. See, it goes from 14 to 15. You see that?
Yeah, I do.
But the actual franchise agreement skips to page 89. You see that in the bottom right corner?
Yeah, I do.
And when you went back or pulled out the file, this is the document that you had on file for the franchise agreement?
Yes, it is.
So Westpac doesn't have a copy of the first 88 pages of the franchise agreement?
I can't confirm or deny that. I don't know that.
You don't know. Well, in any event, no one's provided it to you, the first 88
I haven't.
pages.
Thank you. Yes, correct.
And you made the point that this franchise agreement was dated the 6th of August 2010?
Yes, I did.
You made that specific point this morning as to the order in which things happened?
Yes, I did.
All right. And if we go to the page ending .9122, you'll see, have you got that page open, Mr. Welsh? 9122, we haven't come to that yet on the screen, but that's all right if you've got it in front of you.
No, I do.
And you'll see it sets out what the initial franchise fee is. You see that? About a third of the way down the page, item 13.
Yes.
And item 13A has 6 elements to it, comprising the aggregate that together comprise the initial franchising fee.
Yes.
And can I suggest to you, you may be very good at maths and can do this in your head, but can I suggest to you that those first 5 elements add up to $85,409.09?
I'll run with your numbers.
All right. And then if we go to page 9127, which is the last page in the document. You'll see item 31 is a special condition. Do you see that there, Mr. Welsh?
Yes, I do.
And you'll see the special condition is a deposit for the sum of $10,000 to be paid immediately and the balance of $75,409.09 plus GST to be paid no later than 31 August 2010.
Yes, I do.
Do you recall having noted the amount of the initial franchising fee when you reviewed this document?
Sorry, can you speak? Which fee are you referring to?
What is defined as the initial franchising fee, which has the 5 elements that adds up to $85,409.09.
Yep.
Do you recall having noted that when you reviewed this document?
Yes, I did note it.
All right, and so you noted that what was to be paid for the franchise was effectively $85,500?
Yes.
And you noted that that was to be paid no later than the 31st of August 2010?
No, I didn't. I didn't know that.
Would the date that the franchising fee has to be paid be a relevant matter to assessing whether credit should be provided?
You want to know the cash flows?
Well, if a borrower is borrowing money in order to buy a franchise, wouldn't it be relevant to know whether or not they've already bought the franchise? This loan I'm sorry, let me break it down. This loan application is being made on the 23rd of September 2010. The franchise agreement that the borrower has provided to your bank shows that the entire price for the franchise or the initial franchising fee was to be paid by the 31st of August 2010. Is that something that you would expect to raise a red flag within Westpac?
No.
What was the money being used for?
That's what a document, this document, you on the facts of it is right. And that I'm not doubting that that's what the money was, but there would have had to be a payment. And as I tried to explain a little earlier, there would have been going through a set process. So, you know, the money would have had to come from somewhere and he was seeking money to buy it. So the loan, he didn't sign the agreements until December. So, you know, sorry, I didn't explore this at great depth.
I just want to understand your answer to that. Are you saying if he had already paid the $85,409.09 by 31 August 2010, he must still have obtained the money from somewhere to do that? Not from you, but from somewhere.
Hypothetically, yes.
And therefore, perhaps he was taking out the loan in order to reimburse whatever source he'd used to pay for it. Is that your speculation?
On this read of the facts, I suppose that could be the case.
Well, you just have no idea, do you?
No, I don't. Sorry, that's why I'm struggling.
No, I understand. But there's nothing on the face of any of the contemporaneous documents from 2010 that enables you to answer these questions.
Correct.
And I want to understand 2 things. The first is, when you told the Commissioner this morning that you'd gone back and looked through these documents and satisfied yourself that it was appropriate to make this loan, and a senior credit manager had also satisfied him or herself that it was appropriate to make that loan, how did you do it without knowing any of this information?
I went through the the collection of documents, including, you know, and made that call of looking at it from end to end. You know, you don't typically, in my experience as a banker, you don't just focus on one document. You look at the whole of the documents, the other conversations with the clients, the timing. You know, it's quite a broad approach that you have to be in. It's not just a linear, tight one document, and that's the only thing one looks at.
And the second thing I want to understand is, how do you believe that the banker satisfied herself in 2010 that it was prudent to make this loan?
So can you just
How do you believe, based on your review, that the banker satisfied herself in 2010 that it was prudent to make this loan?
how do I satisfy myself?
No, how, well, you've reviewed this, you've decided that it was appropriate to make the loan.
Yep.
Do I take it your answer is, well, if you just look at everything from end to end, then you can think that the loan's okay?
I wouldn't want that to come across as flippant. You know, I can't comment what the banker did because I, as you've rightly pointed out, I haven't spoken to them.
And you have no notes other than the deal build request?
So, correct.
Now, let me ask you this, now that we've looked at this franchise agreement, which you've made the point you'd already looked at before and noted was $85,409.09, what's the loan to value ratio for this loan?
Sorry, the loan to value ratio?
Yes.
There isn't a loan to value ratio.
I see. Because what? Why is there no loan to value ratio? Is that because you're not actually purchasing anything of any value that's to be secured by the loan?
It doesn't apply here.
Okay. Why not?
Because we were lending under the general policy, so you weren't looking at a loan to value ratio?
Did you in any way need to consider the amount of money that you were lending against the value of the business that was being bought? Yes. Did Westpac in any way need to consider the amount of money that it was lending against the value or compared with the value of the business that it was buying, that was being bought?
Yes, we would have looked at the value. We would have looked at the amount that was being paid for that, and, as well as looked at the cash flow and a few things.
And so what is the value of the business that's being bought here?
Well, technically, the value is what it was paid for, so the 165.
Well, we've just looked at the franchise agreement, and what was paid was $85,409.09.
On this page, I don't know, as you've rightly pointed out, this is an 92-page document. I don't know what the other pages are. I don't know that, so apologies for that.
When you satisfied yourself, did you come to a view as to how much this business cost?
Did I satisfy myself?
When you satisfied yourself that it was appropriate to make this loan, did you come to a view on the documents as to how much this business cost?
I didn't do a forensic review of how much this business costs, but was I?
Did you do any review as to how much this business
No,
cost?
I looked at it at 160,000 for a mobile franchise with a bit of equipment and a truck seemed not unreasonable to me. I took a reasonableness approach, which is often a judgment a banker has to make.
Can we go to the deal build request, which is tab 20 to your exhibits?
What's the doc ID?
I'm sorry, it's WBC.104.001.9103.
Thank you.
So this is a form that has to be completed internally, Mr. Welsh?
That's
Like-
correct.
And it's a form that's completed by the banker, is that right?
That's correct.
And it was completed on the 19th of October 2010.
That's the date.
Well, that's the date it was submitted.
Yeah, well, sorry, I thought you said when was it completed? I don't know when it was completed. That was
It could have been
the date.
completed before the 19th of October, but it was submitted on that date.
Yes.
And it sets out the building up of the deal. Can we go to page 2, which is .9104? And you'll see the description in relation to relevant...
I've just lost which page is it?
I'm sorry,
It's got
page
some-
2.9104. It should be 2 of 15 down the bottom of the page.
2 of 15. Thank you. Thank you.
And you see down the bottom of the page, relevant recent events. Customers have approached the bank to fund the purchase of franchise in Glenmore Park with a purchase price of $165,000. See that?
Yes, I do.
Using the mother's property as security.
Yes, I do.
Partner is the sole director with the daughter as secretary and the mother as a shareholder.
Yes.
Now, do you agree with me that as at the 19th of October 2010, Ms Flanagan was not a shareholder of this company?
Yes.
And this purchase price, which is said to be $165,000, that is presumably drawn from the loan application? That was the point you made earlier, that it's 165, 5,000 of owners' funds and $160,000 from the bank.
Yes.
And if we go over then to page .9105, which is page 3 of 15, and you'll see there's a box which begins current events in relation to owners, managers.
Mm-hmm.
And you see the statement, Carolyn will be a shareholder of this business and receive a wage and dividends.
Yes, I do.
Now, at that time, she wasn't a shareholder. We've agreed on that already. We also agree she wasn't an employee of the business.
Yes.
And it says she's going to be using her property, though, as security for the loan.
Yes.
And the commercial benefit is said to be that she'll receive a benefit from dividends.
Yes, that's what it says.
And if we go over the page to page 5 of 15, which is .9107, we see at the top of the page the amount of the loan is $160,000.
Yes, I do.
And under the heading risk, risk is assessed at medium.
Yes.
And it has then transaction risk, which is also described as medium.
Yes.
And factual dot points, the first is facility will be fully secured.
Yes.
And you see there's then at the bottom in that box 66% LVR.
Yes.
And LVR is loan to value ratio.
Yes.
And you'll recall perhaps 10 minutes ago you were explaining that loan to value ratio is irrelevant here.
For the, I thought when we were talking about that, maybe I misinterpreted you, I thought you were talking about the loan to valuation of the business.
Yes, yes,
Yep.
I'm right. But you were saying loan to value ratio is relevant. It's just relevant in this case, against the value of Ms Flanagan's property.
Of the security?
Yes.
Yes, that is correct.
And then if we go over the page, you see serviceability,
Yes, I do.
factual dot points. I have taken net profit from forecast at 70% for prudence.
Yes, I do.
And the forecast, is that the profit and loss statements you were referring to before?
Yes, I assume so.
All right. And can I ask, did you understand that this was a new business or the purchase of an existing business?
So it was a new business for the partner, but it was a purchasing of a business in the area of that Paul Works area. So it was both. It was a new business for them, but it was purchasing a new company for them. Sorry, but it was purchasing an existing area that had been up and running.
Page, Ms Flanagan as the guarantor, you see that?
Yes, I do.
And you see then it identifies her employment history.
If you could help.
See about 2/3 or perhaps halfway down the page, there's the underlined words employment history.
Yes, yes, I do.
And it says employment type part-time.
Yes,
And the employer that's redacted is the borrowing company.
yes,
And it says she's employed in the family business.
yes,
And the start date of her current job was the 30th of July 2010.
yes.
Now, we agree, don't we? That just wasn't true.
Yes, we do agree.
And then if we go over to page 15 of 15.9117,
Yes,
you see there's a certificate of quality. I hereby confirm that I have checked that this form is complete and correct. Signed electronically by the banker and dated the 19th of October 2010.
yes.
Have you seen in your review of the file any document that could explain how somebody could say they have checked that the form is complete and correct and yet say that Ms Flanagan had started employment for the borrower on the 30th of July 2010?
So what's the question?
Have you seen in your review of the file any document that could explain how somebody could, on the one hand, certify that the document is complete and correct, and on the other hand, state in the document that Ms Flanagan was employed by the borrower from the 30th of July 2010?
No, I've not seen a document.
All right. Commissioner, is that a convenient
Yeah,
time?
how long this will take, I don't know. What I think I'll do, Mr Hodge, is at least notionally aim to come back at 1:15. That's very much in the hands of the techs, whether they can get it up and running in that time. But if I say 1:15, we'll see how we're going and review what we then do.
Thank you, Commissioner.
gather Mr Hodge, it looks like an out of hours fix, I'm afraid, for the public screens. I'm sorry that should be so. We do try our best to make things available, but for once the technology has defeated us, at least for today.
Commissioner, that's my understanding as well. And the other matter I should mention is we've checked and we understand there's not a non-publication direction made with respect to the name of the franchisor. So there's a bit of real-time redacting being done by Law and Order. They don't need to be concerned about that.
Right.
Mr Welsh, the next document that I'd like to take you to is tab 21 of the... Oh, I'm sorry, just before I do that, I want to show you a different document, which is, can we bring up WBC.407.001.0146? So this is an internal email of some Westpac employees. You'll recall, Mr Welsh, that we were looking at that deal build request that was submitted by Ms Fletcher, the banker, on the 19th of October 2010.
Yes.
And then
Yes.
this then is a chain of emails, and I was hoping you could explain to us what's going on. So there's a person named Andrew De Acampo who's a customer loan representative.
Can you just go down to the next page?
Yes, I'm
just
sorry,
to
if we
read
go to
up?
the
I don't
next
think I
page.
have this document.
Can we bring up
right?
both pages of the email?
Yeah, that'd be good. Thank you. Thanks for that help. There we go. Thank you.
So there's a customer loan representative and he's emailing back to Ms Fletcher, the local business banker, and says he's currently building a deal for the above subject. I'm not sure why that's just gone off. Perhaps if you have a look in your hard copy, Mr Welsh. Oh, I'm sorry, you don't have a hard copy of that
do I?
document.
I don't think I submitted it, sorry.
The gremlins are getting at us, I fear, Mr Hodge.
Commissioner, given that the screens are only visible to the Commission staff and the witness and the Westpac employees, it doesn't seem as if there's a particular need to bring down these documents if there's a non-publication direction, but I'm in your hands.
No,
about that.
at least for the moment. While we have no public screens, I'm afraid, we can at least use them on the screens on the bar table.
Thank you, Commissioner. So, Mr Welsh...
I just, in saying that, I hope I'm not thereby creating difficulties for the media where they are left uncertain about positions. Last thing we need is them to be wondering what they can and can't do. These documents are redacted,
Yes.
so there's no difficulty about these, is there?
Unfortunately, I can actually see in my... The DS is just pointing out there's some respects in which the redaction hasn't been done properly. The media room screen will be cut at the moment, so they can't see the documents. There's only anybody sitting in the courtroom at the moment who can
All right, well,
attempt to peer over.
media
and
have
see
got a
the
hard enough
document.
job without my making it harder for them. I think the best we can do, Mr Hodge, is stagger on as we are.
Yes.
If you would indicate at the point of each document going up on the screen whether there is an NPD relating to it, that I hope will be enough to give everybody notice of whether there's an issue or there is not.
Yes, and there's at the moment there's I think we've sort of come out of control at the moment because there's random redaction being done as we watch this screen, which is redacting things that are not subject to a non-publication direction. So just stop. It's all right. Let's work through this in some sensible way. If you look in the subject, you will see the name of the two borrowers that ought to be redacted. If you look in point number 1 on the first page, you'll see the name of the person who's offering a guarantee that ought to be redacted. This is at the bottom of the page. But in any event, I'll perhaps just indicate what the relevant parts are as I'm talking. There's a non-publication direction that hasn't been fully complied with respect to these redactions. And Commissioner, I apologise, we'll have to work through it as we go. Can I ask you, Mr. Welsh, are you perhaps content isn't not quite the right word, Commissioner, but unfortunately that's the best we can offer you.
Take it or leave it.
Mr. Welsh, Mr. Ocampo.
Can I just, sorry to
Yes.
add to the complexity, but I have this screen of yellow here.
Oh, and Mr. Welsh's screen has gone down. Can we bring him back up the document for Mr. Welsh?
So,
It's not your fault, Mr. Welsh.
thank you. I might have kicked it. Thank you.
Thank you.
Thank you.
Mr. Welsh, you'll see
Yes.
there's an email that's sent by Mr. Del Campo, the customer loan representative, to Ms. Fletcher. Can you just explain what their respective roles are?
Ms. Fletcher is our banker, and the other person is works in our customer loan area, and they would have received the deal build request form. That's the abbreviation of DBRF, and they would be building the deal into TLA and TLW.
All right.
TLA,
And
sorry.
into what, sorry?
Into the system. They would be the tab under 21, they'd be the one putting the information into tab 21,
Right.
the credit memo.
And you see on the second page that it said guarantee being offered by Ms. Flanagan, and then the second dash underneath that, shouldn't it be Cat B as she is not a shareholder?
Yes.
And going back to the first page of the document, you see the response to that third point from Ms. Fletcher is guarantee being offered by Ms. Flanagan should be Doc 2 supported and Cat B. Carolyn's name has been updated in CIS to reflect her middle name. See that on the first page?
So bear with me, please.
You see there's a numeral 3 and then a slash, a forward slash.
Guarantee to be offered by Carnage has been updated in CIS to reflect her middle name. Yes, I do.
And there doesn't
Yes,
seem to be any response to the statement that Ms. Flanagan is not a shareholder.
That's correct.
But now I tender that document, Commissioner.
Exhibit 3.11, emails between Fletcher and Ocampo, 20 October 2010, WBC 40700100146.
And then can we bring up WBC.407.001.0035? This is not a document that's in your bundle, Mr. Welsh. So you see, this is a document that's been produced by Westpac, and it's a company search, and you see the date of the report is the 20th of October 2010.
Yes.
Now, you don't have the unredacted version, so you'll have to take my word that this is a search in respect of the borrower, but you can perhaps see that the registration date is the 30th of July 2010 for the company. You'll see that about halfway down the first page.
Under company information? Am I
Yes.
reading that correct?
Yes, you see company information
Yep.
about halfway down the page, registration date 30 July 2010.
I see that date, yes.
And then if we go over to, well, you see at the bottom of the page, it says share structure and there's only one share issued.
Is that on the second page?
Then at the bottom of the first page, you see class ordinary
Or
shares.
number of shares issued?
Number of
one?
shares issued, and over the page, there's the shareholders, which is redacted on this version, and again, we can perhaps provide an unredacted version to you if this will assist, but you can take my word that the name identified there is the name of the partner, and that doesn't surprise you.
No.
And so what appears to have happened is that Westpac performed a search, or somebody within Westpac performed a company search on the 20th of October 2010. That search showed only one shareholder who was the partner, and hence the chain of emails in which an email is sent saying that Ms. Flanagan is not a shareholder. Do you agree with that? That must be what happened.
Seems very reasonable.
I tender that document, Commissioner.
Exhibit 3.12, company search 20 October 2010, WEC 407 001 0035.
Now, have you seen any document that shows the banker having contacted the borrower or borrowers about the fact that Ms. Flanagan is not a shareholder?
No, I haven't.
Would you expect, if one of your bankers was informed by another section of the bank that what she had been told by the borrowers was incorrect and that in fact the guarantor was not a shareholder, that would be a matter that would put the banker on alert?
Yes, I would.
And what would you expect that she would do about it?
Talk to the client to remedy the situation, talk to the customer to remedy the situation.
And would a sufficient remedy simply be to have the guarantor included as a shareholder?
So I'm just,
Yes, would a sufficient remedy of the situation be to simply have the guarantor included as a shareholder of the borrowing company?
would be one of them, but it would trigger a conversation. Sorry if I'm struggling a bit.
Yes.
It's not. There would trigger a conversation to go and say, hey, you told me something. Hey, it's not quite right. Let's have a look at it and work out what it is. What's the facts here?
And bearing in mind, Westpac wouldn't take a guarantee from a parent, as you've explained already, if there was not a direct benefit from the business borrowing to the parent.
That's correct.
And we've talked about the two direct benefits that were included in this deal build. One was the wages, and we know that's just wasn't the case. That didn't exist. Do you agree with that?
Yes.
And the other benefit was the benefit of a dividend stream from being a shareholder.
Yes.
And there'd obviously been either some inaccuracy or misunderstanding on the part of the banker in relation to...
Sorry, just missed some of the
There'd obviously been some inaccuracy in what was said to the banker or misunderstanding by the banker as to Ms. Flanagan's status as a shareholder.
Yes.
And that went to the heart of the only other remaining direct benefit that Ms. Flanagan could have in relation to the loan to the company.
Yes.
And the bank had taken no step to satisfy itself as to the likelihood that Ms Flanagan would receive a dividend from the company?
So you can just
The
repeat?
bank had
Yep.
taken no step to satisfy itself. I'm sorry, I should withdraw that and break it down slightly.
Thank you.
The bank had taken no step to satisfy itself that even if Ms Flanagan was a shareholder of the company, she had any realistic prospect of receiving a dividend from the company.
I can't see any evidence of the conversation, so I can,
Ms Flanagan wasn't a director of the company,
at this, yes.
well, at any time. She was never a director of the company, was she?
No, she was never director. No, correct.
She had no control over whether or not the company declared a dividend.
That's correct.
The bank intentionally, in accordance with its policy, didn't seek a copy of the constitution of the company.
That's correct.
So it had no idea whether the constitution, whether there even was a constitution for the company or whether the company was operating under the replaceable rules.
That's correct.
It had no idea whether if there was a constitution, it said anything about the circumstances in which the company might pay a dividend.
I can see no, yep, that's correct.
And really then, the direct benefit is satisfied then on Westpac's view in this case simply by the nomination of Ms Flanagan as a $1 shareholder of a company controlled by her daughter's partner. Is that right?
Sorry, I just missed the first part of that question.
Ms Flanagan, well, let me break it down. Ms Flanagan was ultimately, as you know, when you did a search this year,
Yep.
registered as a $1 shareholder of the company.
Yes, she was a shareholder. Yes,
She was never appointed as a director or anything like that.
that's correct. Yes.
It doesn't appear as if, in fact, anyone actually submitted something to Westpac back in 2010 showing that she'd been appointed as a shareholder. Do you agree with that?
I haven't
seen
seen any
anything?
evidence. I haven't seen any evidence.
You haven't seen any document where she consented to be a shareholder?
No, I haven't.
And therefore, when we've been talking all the time about what is the direct benefit that Ms Flanagan was to get out of this company, is it Westpac's position that it is sufficient merely for a parent late in the stage of the compilation or the building of the loan to be noted as a $1 shareholder in the company and there be nothing else?
Correct. Yes, our policy is that if you are a shareholder, then you have rights to, normal courses, you have rights for dividends, and that complies to be counted as commercial benefit for the future.
How often, in your experience, would a proprietary company of this kind pay a dividend?
I'm not sure of that.
Not sure? Can you point to any examples that you have seen in your time as a banker where a closely held proprietary company of this kind has paid dividends to shareholders, as distinct from take wages which are deductible against the income of the company?
In the normal course, there probably would not be dividends at this level.
In the normal course, or am I mistaken? Is an available point of view that it would be rare for a private company of this kind, a proprietary company of this kind, to pay dividends?
Yes, I think that's correct.
Yes.
Mr. Welsh, I want to take you to another document now, which is an exhibit to your statement. It's exhibit number 21. Now this is a later document as part of this process of building a deal, is that right?
Yes, correct.
And if we bring up page 2 of that document, we'll see a section which is relevant recent events. And can we put that on one side of the screen and then bring up on the other side of the screen the document which is tab 20, WBC.104.001.9103. And I just want to show you something, which is if we bring up page 2 of that document on the right, .9104, and what you'll see is this section at the bottom, which is relevant recent events, on the right-hand side begins, customers have approached the bank to fund the purchase. You see that on the right-hand side?
I do.
And then that's the same text that over in the document on the left-hand side, you can see under the section relevant recent events. It also begins, customers have approached the bank to fund the purchase.
Yes.
And if we then go to the next page, .9104 on the right-hand side, and I think what you'll be able to see is that
03 here, if you want me to have 04.
on the right, oh, I'm sorry, should be 05. Thank you. I know the document begins .9103, but we're on page 9105. So the only
I have
thing,
that now. Thank you.
I just want to make this point to you so you understand what we're doing.
Thank you.
The text that is in the document on the right-hand side has been copied into the text in the document on the left-hand side. And the difference is that for some reason the text on the right-hand side gets cut off, so you can't see all of the full context of the sentences. But we know that that text in the document on the right-hand side is part of the document that was completed by the banker on the 19th of October 2010. So I just want you to understand what the source is of the text that I'm now going to take you through. You see that?
I do.
Thank you. So we can bring down the document on the right-hand side and just focus on what's on the left-hand side. And what I want to go back to is this question of what exactly is the business that is being bought by this borrower. And you see what's recorded is customers have approached the bank to fund the purchase of Poolworks franchise in Glenmore Park with a purchase price of $165,000 using mother's property as security. Do you see that?
Yes, I do.
And if we just pause on that and go back to the first page of this document, you see in the middle of the page, you can see, about a third of the way down the page, you can see total lending value $160,000 and loan to lending value 100%.
Yes.
I just want to understand, does that mean all that is being looked at here is what percent of the total loan is being loaned out by Westpac? There's no other consideration of the loan to value ratio.
And does that 100% in that box there, is that what
Yeah.
that means?
Yes. Is
Yes,
that right?
it's the 160 by the 160.
Yes, all right. And then if we go back to the second page, where we were looking at relevant recent events, we see that what's explained is about a third of the way down the page, customer, and it's blanked out, but that's the partner, has worked with a Poolworks franchise previously for 2.5 years in Penrith until the previous franchisee was terminated. And then you see a paragraph down, Poolworks are very excited about moving forward with the partner, and he will be looking after areas from Glenmore Park, Cranbrook and Kingswood with existing clientele. You see that?
Yes, I do.
And then partner has a big shed that he will be working out of to start with, keeping his cost minimal. This will be a mobile service in which Poolworks are happy with this arrangement. You see that?
Yes, I do.
And then partner has been working for Poolworks for the past 3 months, servicing their customers in the above area since the store in Penrith closed, and is estimating that in 2 months trading the income has been $32,000.
Yes, I do.
And so I just want to make sure that this reflects your understanding of what the particular state of the business was. First, there had been a franchise in Penrith for Poolworks. That was your understanding?
Yes.
And that franchise had operated from a store?
Yes.
And the partner had worked at the store?
And worked in the, well, I don't know whether they worked in the store or the franchise.
Worked for the franchise
Yeah, they were.
that operated from a store?
Yes.
And that franchise had been terminated?
Yes.
And the store had been closed?
Yes.
And the partner had now for 3 months been working directly for Poolworks?
Yes.
And he was now planning to operate a mobile service,
Yes.
and there'd be no store.
Yes.
And so it was going to be a new franchise where the franchisee would be this borrowing company. Is that right?
Yes, that's right.
But it would be operating in a similar area to the previous franchise that had closed down.
Yes, that's correct.
But whereas the previous franchise had been a store, this would be a mobile franchise.
Yes, that's correct.
All right. And that is the understanding that you had when you, after you looked through these documents and concluded that it was prudent and diligent to make this loan.
That is correct.
All right. And then you referred to the profit and loss statements earlier. Can we bring up tab 13 of Mr. Welsh's statement? And that's WBC.407.001.0067. Should be
No, I have it.
tab 13 if
Yep.
you've got it.
Yep,
All right.
got it.
So this is a document headed Glenmore Park Profit and Loss. And you see at the top of the page it says projected sales totals.
Yes, I can.
And it has projected sales totals for the following 11 months.
Yes, I do see that.
It doesn't say what year, but presumably 2010 to 2011.
I made that presumption as well.
And it has a budgeted gross profit margin of 70%. You see that?
Yes.
And can I suggest to you, again, you might be able to do the maths in your head, that $5,253, which is shown as the purchases for August, is just 30% of $17,510, which is the projected sales for August.
You've lost me, but you're
Well,
pretty good
if
at
you have a
this.
look at it, so it's projected sales.
Which one? I just can't find the number, sorry.
Fine. In the top left corner, you see August.
Yep, the-
Projected sales, $17,510.
Yep,
Budgeted gross profit, 70%.
yes.
And the purchases, which is $5,253, what I'm suggesting is that's 30% of $17,510.
Yes.
That makes sense. That would make sense. That's how you read a
Yep.
profit and loss
Yep,
statement.
yes.
Gross profit is $12,257. That's 70% of $17,510.
Yes.
So, and then you'll see there's a series of operating expenses.
Correct.
And can I suggest to you, where there are operating expenses that are calculated by reference to some percentage figure of another number, or some franchise or part of the franchise agreement, so the marketing fees and the marketing obligation, they sort of vary across the year. You see that? So marketing fees, 2% is $350, then $329, that sort of thing.
The variable costs.
Yeah. Well,
Off the turnover.
yes, except that
Yes.
then if you have a look at all the other items, things like communications and motor vehicle and going over the page, various other expenses like accounting fees, bad debts, bank charges, borrowing costs, collection fees, computer costs, repairs, etc. All of those other costs not linked directly to what's being paid to the franchisor are just standard round numbers.
A fixed cost.
And you wouldn't actually, they're just estimates of what the future costs are going to be, aren't they? You wouldn't think
Yes,
that
correct.
a bad debt is not, you wouldn't think that there's a fixed cost of $100 a month for bad debts. Do you agree?
That's the budget assumptions.
It's just the
Yes,
budget
yes,
assumptions.
yes,
And that's
yes.
what you'd expect for
so.
projected profit and loss.
Very much so.
And have you seen any document that explains what the substantive basis is of these projected sales totals?
The document that I looked at from that is if you go to page 4 on this,
Yes?
so these are the 09 and 10 numbers. I assume they are. I don't. And you can see that the total of them is in 09 was 365 and the 10 was 373. And so that's I use that as that's when I was looking at this, they've made those, that was the historicals that I saw.
And you assumed that this document came from whom?
I don't know who it came from, actually.
Right.
I don't know directly, but it was part of, as you mentioned, it was, if I go with your way of working this, it's 6 of 66. 16 of 66, so it was in a package of documents.
And would you ordinarily expect your banker to verify this in any more substantive way?
Ideally, I'd like the banker to have the historical financials from the previous business to be able to anchor them back to. Ideally, you'd like that.
Because, you tell me if I'm right about this, these are gross sales, that document you were pointing to a moment ago on page 4, these are gross sales for a mobile business in Glenmore Park.
That's what it says.
And that wasn't the franchise that had shut down. The franchise that had shut down was a store in Penrith. Do you agree with that?
That's an assumption. I don't know whether that's right or wrong.
Well, no one knows really then what these figures are for, do they?
Well, it's you don't know 100%, and exactly what these figures are. No, I can't say that, sorry.
All right. And so, though, what has been done in terms of serviceability is if we come to... Oh, I'm sorry, just before we do that, just go back to the start of tab 17. And when this is setting out projected sales totals, and then move over to the third page where you see net profit. And you see in the bottom right corner, the net profit projected for the year is $90,106.
Yes, I do.
And if we then go to the serviceability worksheet, which is tab 19, and that's come up on the screen, and you see the adjusted EBITDA is said to be 63, which means 63,000.
Yes.
And at the bottom it said net profit forecast taken at 70% for prudence.
Yes.
So that the EBITDA figure has been arrived at by taking that $90,106 forecast profit figure, applying 70% to it, and then taking that as the adjusted EBITDA. Do you agree with that?
Yes, I do.
And that then seems to be the limit of the assessment that's done on the ability of the business to service the loan. Do you agree with that?
These are the key numbers used, yes.
And again, from your perspective, what you would expect one of your bankers, being diligent and prudent, to do, does that appear to be sufficient?
Yes, it does.
Right. And the consequence then is there's some figures that are given for projected profit and loss where there's no source identified for those figures? On the documents that you've seen that you can file?
I can't see what the source was on the documents I've got.
And there's a document that appears to be the projected, or I'm sorry, appears to be the last 2 years of gross sales
Yes.
for a mobile business where in Glenmore Park, where it's unclear exactly whether this is the same business that's being taken over or it's a different business. Do you agree with that?
I hesitated because I can see how you might have read that. When I
Yes.
reviewed the file, I didn't read it that way.
You read it as this is the business that's being taken over.
Yeah, I read it, this is the business that's taking over, this is the historicals. They had a 373 turnover and we took 65% of that to get the numbers here took 65% of that to get the projected sales, so they discounted them back from the previous business. So when I looked at that, I thought, pretty reasonable sort of assumptions.
Would you expect, just as an example, to at least see if this is an existing business that's being taken over, and that's the assumption that you made,
Yes.
would you expect to at least see then the last 2 years of full financials for that business?
You'd like to see them if they're available.
Isn't that what's required under your policy for an existing business, that you would get the financials that exist?
Yes, it's the preference to get them.
All right. Sorry, when is the preference? Does that mean it's optional?
Well, if you can't get them,
Yes.
you don't, in my experience, you can't say, sorry, we can't lend you money because the previous business isn't going to give their accounts to you. We'd probably not lend too much if that was,
Well, you'd say it if you didn't have Miss Flanagan's house as security, wouldn't you?
I think you'd want to, I'm hopeful that there was, I'd like to think there was the right inquiry here, but if you can't get them, you can't get them. If you can't get the financials, you can't get them. You have to then work with it and try and piece together the jigsaw puzzle of what became this deal.
Because Poolworks was an accredited franchise with Westpac, you had information about the performance of Poolworks franchises?
There was some information.
And
I,
in reviewing the documents, have you seen any reference to the utilisation of that information to assess this application for a loan?
no, I haven't. I think from memory, and I might have I might have not communicated properly. I think Poolworks was accredited at a later date after 2010.
Oh, I understand. They may
So
not have been accredited.
they might not have been
then,
accredited
So you may
there
not
at
have had
that-
the
yeah, so that
information.
time.
I
So-
apologise, I understand.
No, I think I took you down the wrong path.
And can I return then to a topic we've hit on a number of times this morning, which is what this money is actually going to be used for? Would you expect your banker to know with precision who was going to be paid with this $160,000?
Not with the precision that you went through to. No, I wouldn't.
Well, let's break that down a little bit more. Would you expect them to know how much it was actually going to cost to purchase the business itself?
Yes. I would expect them to know the total amount. So the 165. That's what That's what I'd expect them at this level.
But what is again, I feel like we've run around this a few times. What is the 165,000 actually for? Is it for the cost of the business plus working capital plus stock plus vehicles, or is it just for the business? What is it for?
Plus the rights to operate with the brand and the support of the marketing to operate the Poolworks franchise for a business that historically had a 300,000 turnover and on the forecast was going to have a 240,000 turnover and make $90,000. Now, that seems not unreasonable to me on my review of the file.
But what you wouldn't expect your banker to have figured out then is, does it cost $85,000 for the franchise rights?
Correct. Correct.
And if your banker had figured out what is apparent on the face of the documents, that it costs $85,000 for the franchise rights, would you have expected your banker to have figured out what the rest of the money was being used for?
Not necessarily, no. I would have thought the banker would have taken on good faith with a bit of reasonable judgment that that level at 165 was not unreasonable. As you say, I don't see the other documents here. There might have been more of that 90-odd page document, so I can't tell what they did, sorry.
And when you say you wouldn't expect the banker to do that, is that because always what you know about this and what the banker knew was that Ms. Flanagan's house was going to be on the line and securing the value of the loan?
No.
If they were having to lend against cash flow from a business, would you expect your bankers to be more diligent in actually understanding what it was costing to buy the business and what the cash flow was going to be?
Hypothetically, yes, if that was the case.
And so it's because the only security, or it's because the security available is Ms. Flanagan's residential home, that affects the approach that you expect your bankers to take to being diligent and prudent.
No.
I'm not sure if we're at cross purposes then. You agree with me that you would expect more in terms of the assessment of what the cost of the business was to purchase and what the cash flow of the business would be if the bank was lending against cash flow?
Yes.
And that in terms of what you would expect a diligent and prudent banker to do, they would need to satisfy themselves as to exactly what the purchase price was in that circumstance if lending against cash flow?
Yes, that's correct.
And they would need to satisfy themselves as to exactly what the basis was of the cash flow if lending against cash flow.
Yes, that's correct.
But in this case, that's not what you expect of a diligent and prudent banker, is that right?
In this case?
Yes.
That's correct.
And that's because Ms Flanagan's home is on the line.
No, that's not correct.
So why is it?
So the way you put the previous, let's take that hypothetical example of looking at cash flow lending. It's a pretty complex operation. You'd expect historicals of the financial, they might have a CFO, you'd have a lot more information. And so you would expect that for a cash flow deal. That's why, banks are reluctant to lend to cash flow lending unless because it's pretty sophisticated, as you've unpicked through this. So when you get a small business, you're not putting the partner through the show us your cash flow, show us your historical, show us your sensitivities and those sorts of things. You're trying to take a reasonableness approach to lend to small business so you can help them and back them to get into the deal they want to do. So, and when I said to you earlier, I looked through this and thought, well, a business that's dropped that's this type of turnover, this type of profitability, for a $160,000 deal, that's about the right of amount of focus you want it with the inquiry, because if you can't get the financials, you can't get the financials.
When you turned your mind to the question of whether it was reasonable to make this loan, did you proceed on the assumption that the borrower had already paid $85-something thousand for the franchise agreement rights?
No, I didn't.
So you thought that the borrower had already breached the agreement that required that payment to be made by the 31st of October 2010?
I didn't actually think about it. Actually, I didn't look through it in that lens.
Okay.
That's not a lens I even considered.
No. Your point is really you just didn't consider what was being paid for the franchising rights specifically?
No, I'm not trying to give that. I think you're placing a lot of importance on it. I didn't. As an experienced banker, I looked at the cash flows, I looked at the reasonableness, I looked at 165K for a business. That's the sort of assumption. I didn't get into the detail of, did you have the truck? I didn't. So that's, sorry, we probably are at a bit of cross purposes. You'll bring a different lens to it than I would expect from a banker.
And if we go to Exhibit 39 to your statement, these are the bank statements. And can we go to WBC.407.001.0286? So you'll see this is the first statement for the loan. This is when the loan is first opened on the 22nd of December 2010. See copy of statement number 1.
Mm-hmm.
And on the 22nd of December, there's a staff-assisted withdrawal of $135,000.
Mm-hmm.
You see that?
Yes, I do.
And I understand you to say you don't know what that money was used for specifically.
No, you're correct.
And it's just not really relevant to whether or not a banker exercised diligence and prudence in making this loan.
Sorry, I don't understand the question there.
It's why it's $135,000 if the purchase price of the business is $160,000 less $8,000 working capital, and yet the amount withdrawn is $135,000, or why it's $135,000 when the amount that had to be paid to the franchisor was $85,000. That level of detail just doesn't matter.
I'm not following your line of question because
Did you expect that the initial withdrawal that was going to be made was to purchase the business?
Mm-hmm.
You did?
Well, the final payment of whatever it would have been.
And what was that final payment?
I don't know that.
All right. Because, and it's not your fault, you didn't make this loan.
No, no.
But when you go back through the Westpac documents, nothing tells you this information.
Of exactly what was paid for the loan?
For the business, nothing tells you that.
Well, other than the fact that the customers said it was going to cost 165,000 and we approved 160,000 loan, and they were working in the business, and there would have been, I suppose I'm just struggling a bit because there would have been cash flows moving around a bit. They were working in this business. By this stage, this is late December. They'd already been working in it for a couple of months. I don't know what happened in between that, and deals change and move around. They might have, who knows? I don't know. So, but it doesn't seem unnormal to me.
All right. And then if we go
So
to
that's-
page 2 of that document. So these are some other payments that are made from this loan account. By January, not all of the money has been taken out. You see on the 5th of January, there's an online payment made to Sydney Water.
Yes.
And then on the 1st of February, there's another online payment made to Sydney Water.
Yes, I do. I got the
And then
water
if you
payments.
go to page 3 of 4, oh, I'm sorry, I missed something. Go back to the 1st of February 2010 on the previous page, page .0287. You see there's a withdrawal, internet online banking, payment rent, $1,800.
Yes.
And you remember the business plan and the deal says that the partner owns a shed and is going to operate a mobile business.
Yes, I do.
And then if you go over to page 3 of 4.0288, you see 28 February 2010, another payment for rent, $2,800 this time. And let me ask you first, did these particular payments that I've pointed out to you, do any of them cause you concern about what this loan was used for?
I'm not sure why rent would be paying.
You don't know why rent would be paid? What about why this business would be paying Sydney Water?
Not sure.
And as I understand it, to go back to a point I've made to you a number of times, it just doesn't matter to Westpac what the money was being used for, did it?
No, I don't think that's correct. I don't think that matter. You want to get very clear of the purpose of the loan. You want to establish it up. What would be a correct statement is, I don't want my bank. I don't think I want my bankers reviewing every statement to see what every payment is, and I don't think our customers want them to see that. There's an element of the relationship that built up of what they're going to run, how they're going to run their business, and you control it by the limits and those sorts of things. I'm not expecting them to go through to find out whether they've been paying water.
One of the things...
I don't think that's the role of the banker.
Yeah, I'm sorry?
I don't think that's the role of the banker.
I understand. One of the things that you're saying, if we provide what is effectively an overdraft facility to a customer, we shouldn't be checking exactly what that customer is using that overdraft facility for. That's not your role.
Well, yes, yes.
And if a customer comes to you and says, we're going to purchase a business and the cost of purchasing that business is $160,000 and we want a loan to purchase the business, it's also your view that it's not the role of the bank to figure out whether in fact the purchase price of the business is $160,000.
I think that's a bit more literal, so apologies if I've given you that impression. They should do a reasonableness test to sort of say it's 165,000 about right for a full franchise.
I think I don't really understand this. If you're purchasing a business, you sign a contract and the contract has a purchase price in it. Do you agree with that?
I don't know in the circumstances what they signed because I couldn't see it, so.
Well, you saw one document and it showed that the price for the initial franchise fee was
I
$85,000.
saw one page of the document and one part of it. Yes, correct.
And the reason this really matters, Mr. Welsh, is because we need to grapple with this question. Is the problem here the problem with Westpac applying its standards and policies in this case, or is the problem a problem with Westpac's standards and policies? Or is there no problem at all? And you obviously think there's no problem at all. Is that fair?
I think that's fair.
Right. Now, I want to ask you then about the guarantee and indemnity. You've obviously reviewed these various guarantee and indemnity documents, Mr. Welsh.
Yes, I have.
And have you reviewed the original copies that your solicitors showed to the Commission yesterday?
Yes, I have.
Okay, and when did you review those?
When I saw them, which was Sunday.
Okay. And did you form a view based on reviewing those documents as to what sequence of events you thought had occurred in relation to the guarantee and indemnity?
I'd formed a view already on what the sequence was.
Okay.
So it wasn't, I didn't form a view because of those documents.
Well, let's have a look at the document. So if we go to tab 27. This is the guarantee and indemnity signed ultimately by Ms. Flanagan.
Yes, it is.
And Ms. Flanagan believes she came into a Westpac branch. As to that first point, did she come into a Westpac branch? Westpac also believes she came into a Westpac branch.
Yes.
And Westpac, or you on behalf of Westpac, believe that Ms. Fletcher, the banker, met with Ms. Flanagan?
Yes.
And if we just go to the document, if we go to page 5 of the document, which is .9137. Sorry, actually, before we do that, can we go to page 1 of the document, which is .9138? 9138. I'm sorry, actually, that's the form of acknowledgement over the page from the document. So just make sure we understand each other on this. This is a standard form document, this form of acknowledgement that appears in Westpac guarantees at the time.
Yes, it is.
And there's a series of questions that the guarantor is supposed to answer before signing the form.
Yes, it is.
And
Yes.
is it your belief that Ms. Fletcher, the banker, filled in the yeses on this questionnaire?
Yes.
And so the first question that Ms. Fletcher filled in yes to was, have you read the guarantee and indemnity and the memorandum of common provisions booklet carefully? And she wrote yes. On behalf of Ms. Flanagan, you agree with that?
Yes, I do.
Now, she could have written no and then answered the question, did you have the documents read out or translated for you? But she didn't do that.
That's correct.
And can you think of any explanation for why Ms. Fletcher just wrote yes in response to the question, have you, that is Ms. Flanagan, read the guarantee and indemnity?
Hypothetically?
Well, you must have thought, you formed the view that Westpac complied with all its processes in relation to the taking of the guarantee. So what's the view you formed as with respect to this question?
The view that I formed in respect to this question is that, as I heard from Ms Flanagan yesterday, it was read out to her, this was an error, and that she should have put no in the box that said, if you've answered, she should have put no there, and then acknowledged that she read the documents out to her that we heard Ms Flanagan say yesterday.
Right.
That's what should have happened.
And you believe that Ms Fletcher met with Ms Flanagan before Ms Flanagan met with a lawyer, is that right?
Yes.
Right. And that it was at that time that Ms Fletcher, when she met with Ms Flanagan, filled out this questionnaire?
When she went, it was at this questionnaire was
order
filled
of
out in the
events-
meeting.
Yes.
Yes, yes,
Well, let's make
yes.
sure we're clear about this.
Yes, please.
The questionnaire was filled out by Ms Fletcher in a meeting with Ms Flanagan,
Yes,
and after that meeting, Ms Flanagan went and saw a lawyer.
that is correct.
That's your belief?
Yes.
All right. And then you see question number 3.
Mm-hmm.
Within the warning box on the front cover of the guarantee and indemnity, we have stated that before you sign the guarantee and indemnity, you should get advice from your own lawyer and from your own financial advisor, such as an accountant.
Mm-hmm.
You see that? See that question?
Yes, I do.
And below it, it says, answer yes alongside one of the following that is true. See that?
Yes, I do.
And the alternatives are A, you got that advice, B, you got advice from your own lawyer but not from your financial advisor. You see those alternatives?
Yes, I do.
And the banker has written yes next to you got that advice,
That is correct.
meaning you got advice from a lawyer
Yes.
and you got advice from your own financial advisor.
That's what that says there, yes.
And informing the view that Westpac properly complied with its process in relation to taking a guarantee, do you have some explanation as to why your banker wrote yes next to that question?
Yes, I do.
And what's that?
When the banker is walking through this with the client, with the customer, and answering these together, they're filling out the forms to help them. It's not uncommon for these to be filled out in anticipation of something happening, so in anticipation that she was going to go and see a lawyer. So my read of these is that she filled out yes here, that they'd had the discussion about going and seeing a lawyer. So that's not uncommon, because this document was not intended to be signed here. So it was going to be signed at a later date with the lawyer.
Let me make sure I've understood the position that you're presenting, which is that you find nothing surprising, nothing inconsistent with Westpac's policies with writing yes in advance to the question, you got that advice, past tense.
That is often the practice
Within Westpac.
to help fill the form. Yes. Oh, sorry, not often. I don't know that. That's an opinion. It could be the practice at this point in time. It's not fair to say it's often, because I don't know that.
All right, and then I'm sorry, I should just check one other thing, which is there's then a series of questions. First 4, which is about, do you understand that is your risk? See that?
Yes, I do.
That's also filled out yes. You see that?
It says, yes, I do.
Oddly, you actually only need to answer that question if you've answered yes to question 3B, but nevertheless, for completeness, Ms. Fletcher has pre-filled out that to assist the guarantor. That's your reading of what's happened.
Yes.
And then if you go over to 5, there's a series of things that the guarantor is asked to confirm that she understands. And the first is, if you sign the guarantee, you may have to pay the lender a lot of money to repay the debts of the customer. The second is, if the customer does not pay on time money he or she owes to the lender can demand that you pay the money in place of the customer or as well as the customer. The third is, if you do not pay that money to the lender, then amongst other things, the lender can sue you, and or if you give a mortgage or other security which secures the guarantee, the lender can enforce it. There's an explanation, a further explanation of what that means. D, the lender can demand that you pay money to the lender if for some reason it cannot recover the money from the customer. E, you should check for yourself whether the customer will be able to pay his, her or its debts, even if the lender tells you something. That is, even if Westpac tells you something, you should still check it for yourself and get an accountant to check it for you. And then I just want to understand, each of these is answered yes by Ms. Fletcher, helpfully assisting Ms. Flanagan. You agree with that?
Yes, I do.
And you don't think that necessarily means that Ms. Flanagan understood that at the time. This might just mean that hopefully she'll understand it in the future, and Ms. Fletcher has helpfully already filled it out. Is that right?
No, that's not right.
So you would expect Ms. Fletcher to have at least satisfied herself about these things first. Is that right?
I would have expected Miss Fletcher to have a conversation, because this is if you sign the guarantee, and she would be having a conversation with Miss Flanagan. So these would be Miss Flanagan's answers to the question that she was reading out these as she went. Because
Yes, but if she has read out the question, have you got legal advice? Ms. Flanagan's answer at the time must have been no.
unless my hypothesis was that it was anticipation that she was going to get the legal advice.
That's right. So
Yes.
is it also possible that in anticipation that Ms Flanagan might understand these things, Ms Fletcher wrote down yes?
That she might understand them? Did
Yes,
you
in
say?
the hope that she might understand them in the future?
It's possible.
You just have no idea,
Correct.
because your processes have not been complied with in this case.
No, I don't see that. I don't buy that proposition.
All right. And then, you see 7, have you received a letter from us which attaches copies of the business finance agreement and other documents / statements?
Mm-hmm.
And again, the answer is yes.
Mm-hmm.
So you need to say, just for the
Yeah.
record.
Yes.
And have you been able to find any letter addressed to Ms Flanagan enclosing a copy of the business finance agreement and other documents?
I did not. I cannot recall seeing one.
And then if we go to page 5, WBC.104.001.9137. So this is the actual guarantee that's been signed.
Yes.
And I just want to make sure we all understand which bits Westpac says were signed when. And as I understand it, the date at the top, 8th December 2010, Westpac believes that was filled out by Ms Fletcher on the 8th of December 2010.
Yes,
The signature of Ms Flanagan, Westpac believes that wasn't signed on the 8th of December 2010,
yes,
and that in fact, based on pen colours, it was signed 2 days later.
more than pen colours, I think.
I'm sorry, pen colours and also the certification from a solicitor that Ms Flanagan signed it 2 days later.
The certification of the solicitor was the one that we ranked over the pen colours.
All right. And then there's 2 witness signatures. You see that?
Yes, I do.
And one of them is a witness signature of Ms Fletcher, the banker.
Crossed out? Yes, I do.
And one of them is a witness signature of the solicitor.
Yes,
And Westpac believes that Ms Fletcher signed as the witness without having seen Ms Flanagan sign the document. Is that right?
yes, yes,
And that then subsequently that document, and I'm sorry, so Ms Fletcher on the 8th of December signed this document as the witness without having seen Ms Flanagan sign the document?
she signed and crossed it out. Yes.
Or did she cross it out or did the solicitor cross it out?
Don't know.
And is it normal practice within Westpac for bankers to helpfully pre-witness signatures that they haven't seen done?
Oh, not at all.
So this is definitely not in compliance with your processes.
Filling out, sorry, I thought if your question is do we pre-sign something of witnesses we haven't seen? No.
But in this case you have. In this case, the banker has pre-signed as the witness without, on your view, having seen the guarantor sign the document.
Well, in my view, she did this in error and crossed it out. So that's the view I've formed. You've formed a different view.
Or the solicitor crossed it out.
Or the solicitor, that's...
You don't know.
No, I don't know.
But in any event, she certainly signed this document without having seen it first signed by the guarantor.
My view is she signed it in error and crossed it out.
And filled out this form of acknowledgement on behalf of Ms Flanagan in anticipation that Ms Flanagan would receive legal advice. Is that right?
Yes, that's correct.
All right. And just go to page .9140. So this is another one of Ms Flanagan's signatures. This is confirming the form of acknowledgement.
That is correct.
And Westpac's view as to when Ms Flanagan signed this is what?
On the, in front of her lawyer.
Okay, so not on the 8th of December.
That is correct.
And who dated it as the 8th of December?
I don't know that.
But in any event, Westpac, on your view, that is the relevant banker, must have known that that was incorrect, that it hadn't been, the form of acknowledgement hadn't been signed on that date.
That date is incorrect, yes.
And the Westpac banker receiving that document must have known that that date was incorrect.
Yes, correct.
And would you expect any of this to have raised concerns about the adequacy of the adequacy of the following of Westpac's processes in relation to the taking of this guarantee?
So would I...
Any of the things that we've just looked at in relation to the signing of this guarantee, would you have expected this to create an issue within Westpac as to whether Westpac's processes were being adequately followed in taking this guarantee?
The imperfections or the errors would should have raised some questions, but as I've worked through with you, I think that I'm comfortable the process was followed correctly.
Why not just print a clean copy of the guarantee and let Ms Flanagan take that to a solicitor?
Right there in the meeting?
I assume there are printers in most branches of Westpac.
Yes, there are.
Why not just print a clean guarantee and let Ms Flanagan take it to a solicitor?
That is an option. Actually, I'm not sure that it is an option because as a control of this document comes from the loan centre. So I might be stretching it a bit here, but I wouldn't want documents that could be changed being printed by bankers in business banking centres. So, but I'm sorry, I don't know the answer to that one. But you wouldn't want just any banker being able to print out any document and being able to amend it. You want, normally the controllers, we get them from the package from the loan centre, done independently.
Can you see that having a banker pre-fill out the things that the guarantor understands, including that the guarantor has received legal advice, might have an adverse effect on the likelihood that this checklist will be properly worked through by a lawyer?
In normal circumstances, yes. Ms Flanagan was, as she identified, was not able to see the document. So, I think it was a complex one. It was one that a banker probably wouldn't have normally come across.
Well, Ms Fletcher completed these questionnaires for each of the three guarantors. It wasn't just Ms Flanagan, was it? It was Ms Flanagan and the daughter and the partner.
That is correct.
And she just went through and answered yes to all of these questions.
I don't know what she did.
Well, you've got them. You've exhibited them to your statement. Have you looked at them?
Yeah, yes, I have.
All right. So she went through and she filled it out for each of them. Do you want to go and have a look at an example?
No, we don't need to.
Okay.
Yes, she filled them out. Sorry, I misunderstood your question. Did she fill them out? Yes, she did.
Okay.
In the same way.
And then with the mortgage, can we go to that, which is tab 28? So this is the mortgage of Ms Flanagan's house in favour of Westpac.
Mm-hmm.
And we go over to the signature page on page 2.0149.
Mm-hmm.
And we see a date at the top, 8 December 2010. Does Westpac have a view as to when that date was filled in?
Yes.
And when was that?
On the 10th, as per the 10th of the 10th, as per the solicitor certificate.
So you think on the 10th somebody wrote in 8 December 2010?
Sorry, I might have misunderstood your question,
I
sorry.
understand. This is not your fault, Mr Welsh. You're here to attempt to explain this. If you didn't do it, if you have a look at the top of the page, you see date,
Yep.
8 December 2010.
Yes, I do.
When do you think that date, or when does Westpac think that date was filled in?
I'd imagine, sorry, I misunderstood your question. The 8th of the 12th of 2010, I think the date is the date.
And then again, we see a signature of the mortgagor, that's Ms Flanagan, and as I understand it, Westpac believes that was signed on the 10th of December 2010 with the solicitor, is that right?
That's correct.
And there are two witness signatures, one of which is crossed out,
Yes, that's correct.
and the crossed out one is the banker,
Yes, that's correct.
and that's normal practice of Westpac, is it, for a banker to pre-sign a mortgage as a witness?
No, it's not.
And this, of course, is something that's been this is not new. Westpac's known about this for some time. It went to FOS. This didn't raise red flags as to what on earth was going on. Did you investigate it? Did you try to understand what had happened? Did you look into why it was that a banker was pre-witnessing a mortgage?
Have I looked into it, or sorry?
Have you or anybody else at Westpac looked into it?
I can't comment on whether other people have looked at it. I didn't look at that. I looked at this, and interesting enough, as you rightly point out, FOS made the same conclusions that I have as well in their report. So, I tended to focus on that part of it.
Well, let's talk about exactly what it is that you're focusing on. What you're focusing on is, ultimately, Ms. Flanagan signed these documents with a lawyer present. That's your point.
Yes.
But the questionnaire that had to be filled in was filled in by Ms. Fletcher at an earlier time.
Yes.
You can't find a record of having provided copies of the business lending agreement to Ms. Flanagan?
No, that's not correct.
Oh, you can.
No, you asked. So there's a record that the certificate that she'd signed later that she gave the business finance agreement. What I said earlier, and again might have, the letter, you asked me whether the letter attached to that. I haven't seen that letter, but I have seen the business finance agreement. I have seen her certificate that says she gave the business finance agreement to Ms. Flanagan.
Oh, sorry, you've seen the banker's certificate, is that right?
Yes.
The same banker who pre-signed as a witness for a mortgage.
The same banker.
And then if we go to tab 26 to the exhibits to your statement. So this is the document that the declaration that's made by Ms. Flanagan in the presence of the solicitor.
Yes, it is.
And it appears as if each part of it is filled in, save for the signature of Ms. Flanagan, by the lawyer. Ms. Flanagan's name, her address, who the borrower is, what the bank is, what the property is, what the two documents are. That's all filled in by the lawyer.
It does look to be similar writing to their name and address.
And then the only thing that Ms. Flanagan has signed on that page is as the signature of declarant.
Yes, that's correct.
And you see paragraph 2 of the declaration is, I have received independent legal advice regarding the loan and security documents referred to in paragraph 1.
Yes.
And the loan and security documents are said to be certain loan and security documents between the borrower and Westpac.
Yes.
And do I understand you to say Westpac believes that at some point in time it provided those documents to Ms. Flanagan?
Yes, yes.
And when does it believe that it did that?
In that meeting that we talked about on the 8th, and yes, they were.
And the basis, so just to be clear, Westpac doesn't think that it had provided those documents before the 8th of December.
Thank you. I don't have a view on that. I know that they were. I assume that they were provided in the meeting because she had to take her through them. So that's an assumption on my behalf.
Right.
Yes.
And then can we bring up, this is an exhibit to Ms. Belgari's statement. This is tab 7 RCD.0024.0001.0111. So you're aware that Ms. Belgari wrote to the solicitors and asked for a copy of the file?
Yes.
And you'll see this is the letter that the solicitor sent in response, which is, please find enclosed our file for Ms. Flanagan as requested.
Yes, I do see that.
And can we just have a look at the documents that are in the file? The first document is a certificate of title. That's page .0112.
Yes, that is a certificate title.
And then the second document, starting on page .0113, is the guarantee.
Yes. Yes.
And then the third document, starting on page .011, I'm sorry, actually, we'll go through this. Next page, .0114, this is the next page of the guarantee. Then .0115, this is the next page of the guarantee. Then .0116, this is the next page of the guarantee. Then .0117, this is the declaration that Ms. Flanagan made.
Yes.
And then .0118, this is the first page of the mortgage. And then .0119, this is the second page of the mortgage.
Yes.
And you can have the operator confirm, but as I understand it, there are no more pages in this exhibit. Now, I want to ask you two questions. The first is, you see on this page, the mortgage is undated.
Yes, yes, I do.
So what appears to have happened is, first, presumably on the 8th of December, the banker at Westpac has signed as the witness without having seen the mortgagor signed. That's Westpac's view as to what happened. Is that right?
Yes.
And then either the banker or the solicitor has crossed out the banker's name.
Yes.
And then the mortgage has been taken to the solicitor and Ms. Flanagan has signed as mortgagor, and that's been witnessed by the solicitor.
Yes.
And there was no date on it at that time
There's no date on this.
when it was witnessed by the solicitor.
There's no date on the 0119. Is that the one?
That's right.
Yes, yes, I can see that.
And then somebody has filled in the date after the 10th of December 2010 as 8 December 2010.
It appears that way, yes.
And do you know who did that? Was it somebody within Westpac?
I don't know.
No. And the file doesn't seem to include any copy of the business lending agreement. What I'm wondering then is the only thing that Westpac can point to indicate that a copy of the lending agreement was provided to Ms. Flanagan so that she could take it away, that there's been some form that's been filled out by the banker?
Sorry, I'm not quite sure of your question.
I'm
I've
just
got a little
trying to
lost here.
understand, what is the thing that Westpac points to in order to be able to say the business lending agreement was given to Ms. Flanagan on the 8th of December and she took it away?
The interview checklist under tab 30.
Okay. And so if we go to tab 30, we bring that up. This is a checklist completed by Ms. Fletcher on the 14th of December 2010.
That's correct.
And as I understand it, Westpac wouldn't expect this checklist to be completed on the day that these things actually occurred?
That's correct.
And
Not always the case, but that's correct in this case.
well, I just want to clarify that.
Please.
You mean there might be occasions on which a banker does complete the interview checklist on the same day as they conduct the interview?
If they've got all the documents back at the same time, so depending on the circumstances, because there are different circumstances for different deals. So I just wouldn't want to be, this was the right approach for this circumstance. Yes.
Why was that?
Because in this circumstances, they met on the 8th, and then on the 10th they went away and saw the lawyer. So they would have. This is the sort of final checklist that our banker would complete as they packaged up all the documents to send to the loan centre. So you've got to get all the documents back, and all the things have got to be worked through. And I did go and check the date on that because I think this was a Tuesday, so there was a weekend there. And when the banker came back, she packaged it all up and filled it up. That's my read of this. And anyway,
I'm not sure I understand why it's necessary to fill this out after the guarantor has met with the solicitor. Let's have a look at the questions. Question 1, have you met the guarantor and given him or her the guarantee pack personally, which includes a copy of the guaranteed transaction? And the answer is yes. Question 2, have you during the interview pointed out or read out to the guarantor the warning on the front cover? And the answer is yes. See that?
yes, I do. Sorry.
Question 3, have you recommended the guarantor get legal advice and financial advice? And the answer is yes. See that?
Yes.
Question 4, have you given the guarantor the chance to take the guarantee pack away to read the guarantee and other documentation? And the answer is yes.
Yes.
Question 5, have you told the guarantor fully and frankly of the financial problems affecting the borrower, if any, that is only your understanding of the position and he or she should check the position?
Yes.
And the answer is yes. Question 6, have you told the guarantor to get an accountant to check the position of the borrower? And the answer is yes.
Yes.
Question 7, have you informed the guarantor of the bank's requirement that it will require a statutory declaration witnessed by a solicitor who does not act for the bank, the borrower or other interested party in this transaction before the facility can be made available? And the answer is yes.
Yes.
And what is the reason why that couldn't be completed until after Ms Flanagan had seen a solicitor?
It could be.
Sorry?
It could be.
But does Westpac expect it to be completed contemporaneously with it, with the interview?
No.
And the relevant answer that you say is satisfactory confirmation from Westpac's position that Ms Flanagan was given a copy of the finance agreement is number 1, is that right?
Yes.
Because it includes a copy of the guaranteed transaction. Is that right?
So in the guarantee pack, part of the guarantee pack under the code is that you've got to have the letter of offer, the business finance agreement. So that's where she's referring to the pack there. That pack has to have the business finance agreement.
All right. And if we just go over the page to page .0236.
On which, sorry, I'm lost now.
It should be in that same tab. I'm sorry,
I moved around a bit, I think.
it'll be up on the WBC.407.001.0236.
Oh, yes.
I think this is
Yes, I'm with you. I'm
just
following
separated.
now. Yep.
So this is a document that is setting out the witnessing requirements for New South Wales.
Mm-hmm.
And I just want to understand, where does this document come into the picture? When is this provided?
I don't know that, actually.
All right. And so then you see down for bank use only, where documents are signed in the presence of a bank officer, and there's the name of the mortgagor, and the mortgagor is named as Ms. Flanagan.
Mm-hmm.
You see that?
Yes, I did.
And the name of the witness is said to be the banker,
Yes.
and the date is said to be the 14th of December 2010.
Yes.
Can you explain what's going on?
No, I can't.
Now, out of fairness to you, just so you can make any point you want to make about it, I understand that colour copies of the mortgage and guarantee are now been uploaded. I'll just bring those up. That's WBC.104.001.9530. And fortunately I haven't been given the pages, but I understand this is a 70-something page document. So perhaps if I'll just speak to my friend for a moment, Commissioner.
Do you want the originals?
No, just tell me what the pages are so I can find it. Oh, which ones?
Guarantee starts there, decoration.
Can we start with .9590? So this is the declaration, and is there a point you want to explain about pen colours and what inferences you draw from that, Mr. Welsh?
So as part of my investigation, I asked to look at the originals because there was a hypothesis here when I read Ms Flanagan's statement that her stat dec said she hadn't been to a lawyer. So I looked at this and went, look, can you show me the documents? Can I, old-fashioned banking, go back to the real paper? And I had a look at signatures, and first I wanted to get comfortable that the signature was the same, and second I wanted to get comfortable that, what were the pens look like? And it's a bit of a stretch, but I was looking at it and going, the pens look similar. So that was the intent. I hadn't intended this to be our conversation though, but that was my intent.
No, I understand. I understand you were diligently just trying to find out exactly what had happened, and I think, to be fair to you, the point you're making is, and it's easier for those of us who have seen the originals to observe this, that the pen used to sign by Ms Flanagan appears to be the same or similar to the pen used to sign by the solicitor.
Well, that's the point.
And then if we go to the guarantee, which is .9582, and go to .9586,
Yes.
this is a bit harder, but it looks like the pen used to sign by Ms Flanagan is the same as the pen used to sign by the solicitor.
I'm no writing expert,
I'm
so I'm
saying-
on dangerous ground here.
And it may well be, and it seems it's a little unclear whether it's the banker or the solicitor who has crossed out Ms Fletcher's name.
Agreed.
That's your point.
Yeah, yes.
And if we go to the mortgage, which
I'm not
is...
claiming to be a writing expert.
No,
though,
no, I
just-
understand. Actually, we should
Please.
go to the form of acknowledgement, which is .9587. And go over 2 pages. And it's unclear, it might be that the signature there is using the same pen as was used by the solicitor. I understand. And then the mortgage, if we go to .9635. And go over the page. Go over another page. And it, again, because it's blacked out, it's easier for those of us who've seen it to say it looks like the pen that's been used by Ms Flanagan to sign is the same as the pen used by the solicitor. That was the conclusion that you came to.
Yes, it was.
And on that basis, Westpac says that it's entitled to rely upon the guarantee.
Correct.
And it maintains that there were no problems with its process in relation to the taking of the guarantee.
Yes.
And it maintains that there were no problems with respect to the making of the loan in the first place.
Yes.
Because if it had failed to act as a diligent and prudent banker in either of those respects, no, actually, I'll take them one at a time. If it had failed to act as a diligent and prudent banker in making the loan in the first place, then do you agree that it would not be permitted to rely upon the guarantee?
If
Westpac
hadn't
had
been-
failed to... It may be that your
I
answer
think-
to this is
I'm-
you're not
I'm-
sure.
I'm not a lawyer.
You're not
I'm
that's
not quite
fine.
sure of the
All right.
details of that. That's another one out of my depth.
Have you heard of Doggett's case?
I'm not a big case reader, I must admit.
And
It's not my choice of reading. You've had me on a few, but that's not one of them.
all right. But the end consequence was that when Westpac came to seek to enforce the mortgage, Legal Aid took Westpac to FOS, you know that,
Yes.
and at FOS, Westpac maintained first that it was appropriate to take the guarantee, there was no problem with the taking of the guarantee,
Yes.
and maintained that it was appropriate to make the loan.
Yes.
And at least at that point, as I understand it, maintained that the hardship policy didn't quite, this wasn't a suitable case for hardship because Ms Flanagan was a disability support pensioner, so it just didn't seem like there was any realistic prospect that this was a short-term thing.
We made an error here, yes.
And that's the particular error that, in your view, Westpac made, is the application of the hardship policy.
We forgot this was about Miss Flanagan.
Yes.
We forgot that we got into, my read of the documents is we got into legal process and what FOS said and who was on what base and what the thing was when we had Miss Flanagan, when we had identify in her FOS hardship that she was in, that she was looking to stay in a home. And when we finally cut to the chase of that, that's what we did. We gave her life tenancy for her home.
And now under the deed that's been entered into, as you say, Ms Flanagan has a life tenancy in her home.
Yes, she does.
If she needed to move out of her home and wanted to sell her home before she died, then Westpac would, under its security, take $170,000 plus 3% accruing per annum.
That's what the deed says.
And so if, for example, she needs to, for health reasons, move into some other environment, she couldn't sell her home to fund that without first having to discharge Westpac's mortgage, or Westpac first having to pay out Westpac.
That's correct.
Thank you, Commissioner. I don't have any further questions.
Ms Colshan, how long do you expect to be?
5 minutes.
We'll come back at 2 o'clock because I have some questions I want to ask. 2 o'clock. Welsh, I wanted to, before you begin, Ms Colshan, I wanted to ask you some questions. Did the bank know at the time it took the guarantee that the guarantor was on a disability support pension?
I don't know that.
Did it know anything about the income state of the guarantor?
I don't know.
I want to put something to you quite squarely, so you need perhaps to take a moment to think about it before you answer. I want to put to you squarely that the processes which the bank went through to determine whether the guarantor stood to obtain any financial benefit were processes that were more form than substance. What do you say to that understanding of what happened in this case?
Yes, I think that's a correct assumption. It was more form, and the substance was more anchored in the security position and not anchored in the understanding of Miss Flanagan's income or potential to pay back the debt other than realising on the asset in the worst case scenario.
My question was particularly directed to determining whether she stood to gain anything from her association with the business. There was reference in the papers to the wages, reference to shareholding.
Mm-hmm.
What I want to understand is what response you would make to an assessment of those inquiries as form rather than substance, or if you like, box ticking rather than looking at the reality. Now, it's put very tendentiously so that you may face it squarely and deal with it.
I think that's right. The process is to make sure that you check that there's going to be a commercial benefit. There's not any substance behind that to make sure that it's going to happen and it's locked in and it's part of the company rules and regulations, and there's a pathway to see if dividends were the one. So I think it is tenuous at best.
I'm so sorry. Do finish.
Sorry, no.
No, you finish.
Tenuous at best.
Your answer matters. Because the next question is then, why do it? If it's form rather than substance, why do it?
If I may, I'd argue that I'd just like to hear your question, but it's something that's troubling me a bit because...
Yeah, that's why I'm asking
Okay,
you, so
thank
that
you,
you can...
thank you.
And putting it as tendentiously as I can so that you
Thank
can
you.
face it squarely.
There's a reality in that many parents want to back their children.
Yeah.
They want to be able to do that.
And come to me as a surprise, Mr. Welsh.
It's true. And the reality is that in Australia's society, we're often asset rich and cash flow poor. And there's a reality that many businesses, particularly for the young today, it's damn hard to access finance and actually to build up a bit of a nest egg. And even in the innovative and world today, there's less likely to be any security in their own way. So the support of parents is critical.
Yep.
The support of a guarantee for many small businesses is critical. The way the current laws and regulations work is you do have to be able to show commercial benefit. And the question is that should that always be the case when a parent's backing their children? That's one question. And then the other question is, if they are, how do we want to evidence that? So there's a number of questions that flow from that, I think, because I think it's a pretty critical issue for Australian business and for the Australian economy and for the future.
I understand that, and it's that sort of issue that I just wanted you to tease out as far as you felt you could or thought it desirable to tease it out. Now, if there's anything more you want to add it. If you think silence is the best course, silence is always the best course, Mr. Welsh. Up to you.
Silence.
Well, an offer like that.
Thank you for leading the witness.
Who could refuse an offer like that, Mr. Welsh?
Thank you.
Ms. Neskovshin.
Thank you.
You've heard your witness say he prefers silence. Have you got anything to ask?
I do. Mr. Welsh, you were asked some questions this morning about the cash flow projections. They're at tab 13 of your witness statement. The document ID is WBC 40700100067.
Yes.
Later, you were asked some questions about how the cash flow projections worked into the EBITDA in the serviceability worksheet.
Yes.
And you're asked some questions as to whether or not a source could be identified for the cash flow projections.
Yes.
Can I ask you to go to the fourth page, which is 0070?
Yes.
This is headed, you've seen this before. In fact, you took Mr. Hodge to this, but you weren't taken to the note.
Mm-hmm.
The above gross sale figures for financial years 2009 and 2010 are mobile-only invoiced sales. These gross sales figures have been reported by the previous franchisee, are unaudited, and Poolworks have charged service fees on these figures to the franchisee. Do you consider that an appropriate source document for the business banker in assessing the cash flow projections?
As evidence of the historicals?
Yes.
Yes.
Is there something more that you would have liked to see?
Oh, I would have liked to have seen the full historical so you could see the expenses and things if they were available.
And what is the business banker to do if they cannot or will not be provided?
The business banker has to work with what they've provided to try and frame up the deal. And if they can't, then they have to make a call that they may not offer finance if they can't get comfortable with the information they've got.
Thank you. Mr. Welsh, yesterday we were asked some questions in relation to the franchise policy and the sector value ratio.
Mm-hmm.
Could you go to tab 2 of that folder, please? And the document ID is WBC 41000019483.
Mm-hmm.
And it's at page 9628.
Yes, I have it here.
I don't think you're specifically directed to the paragraph, but under the heading target market, there's a second paragraph. Lending under this policy is based on the amount Westpac is prepared to lend against the cash flow of an accredited system. this amount is the sector value ratio, i.e. the ratio of the loan amount to the turnkey value of the business. Was that what you were referring to in terms of the sector value ratio and in the context of the franchise policy?
Yes.
You asked some questions in relation to that. Is it possible for yesterday's transcript to be brought up? In particular, at page 2071. It's around line 22, Mr. Welsh. You were asked to explain why the pool works loan in this case study was not assessed under the policy.
Mm-hmm.
And you'll see at line 25, you said the main reason why it wouldn't have qualified for this one is because they wanted to borrow 100% of the value. And there's what we call here a sector value ratio we refer to in good banking terms as SVR. Typically that's a sort of debt capacity, how much can they afford?
Mm-hmm.
And it would typically be about 50 to 60%.
Mm-hmm.
Did you mean how much they can afford, or what did you mean by that?
It's the debt sizing, what the typical amount that we would be prepared to lend against that, and then the affordability will be assessed by the interest cost cover and the cash flow.
All right. Can we go to the next page of the transcript, please? At line 6, you were asked this question by Mr. Hodge. Does that mean, therefore, that if a borrower is borrowing 100% of the value of the business, Westpac wouldn't expect that the business would be able to support that level of debt? You said, yes, that's correct. Do you wish to clarify that?
So the business, so that's not correct. The business may be able to service that debt from the cash flows, but we wouldn't be lending using the SVR and the franchising policy to allow that to happen.
Thank you. The final matter, Commissioner, is that as you heard a short while before the lunch break, we provided the originals of the guarantee, mortgage and declaration for inspection. Mr. Welsh was taken to them in cross-examination, but they haven't been tendered. Can we please request the tender of that document? I can give you the ID.
Yes, when were those documents first brought to light, Ms Neskovshin? I think I'm right in saying that the Commission was looking for originals for some time, was it not?
They're not my instructions.
Well, won't go into it. Exhibit 3.13 will be Westpac file concerning Flanagan WBC 104-001-9530.
Commissioner, the protocol for producing documents is electronic copies. I'm not sure when inquiries were made for the originals. I can find out. Certainly they were brought to my attention on the weekend, and Mr. Welsh said that he looked at them on the weekend.
A little surprised that they were drawn to attention at 5 to 2 yesterday. 5 minutes before the evidence was to begin, Ms Neskovshin. Yes.
Thank you, Commissioner.
Yes.
Mr. Welsh be excused temporarily. He'll be coming
No,
back
he
tomorrow.
may not be excused. He may be. You may stand down, Mr. Welsh. We will see you again later in the week, I fear. Thank you, Mr. Welsh.
Thank you.
Mr. Hodge.
Could I just clarify something, Commissioner? Is what just got tendered the colour copy that's been provided, or would Westpac prefer to tender the actual originals?
I would prefer the original to be tendered as part of the exhibit, as the exhibit.
It is available in the hearing room and we will
And the
hand that up.
original document should be tendered, I think.
It's an entire security packet which we've kept together to maintain the integrity of the file.
I'm sorry, Ms Nescott.
It's an entire security packet
Yes,
and we'll tender the original.
yes. And are they still current?
Yes,
They're current.
yes. So it has the certificate of title on it. You might like to.
Now, you can remain chained to those, Ms Nescott, and tender colour photocopies of them, and the originals can stay in the custody of your solicitors, but they are to be available for inspection by the Commission on reasonable notice.
Yes, Commissioner.
Commissioner, the next witness is going to be Ms Gibson from ANZ. Can I perhaps just indicate what we propose occur for the remainder of the afternoon, which is that we begin Ms Gibson, and then at about 3:30 we will interpose a consumer witness for the next case study who's available this afternoon, and then I expect we won't have concluded Ms Gibson by then, and we'll conclude Ms Gibson tomorrow morning.
Yes, yes.
Would it,
Just while we're talking about those things, can I say to those at the bar table and those who are about to take their place at the bar table tonight, can you be sure to take away all your books, papers and the like. I think we are likely to be getting scissor lifts in tonight to look at the two projectors, so it would be very important if those who are at the bar table make sure they clear away all their papers and belongings.
thank you, Commissioner.
Yes,
Commissioner, would you like to adjourn for 5 minutes while we
Yes,
switch all of the parties around?
I'll come back at 2:20.
Thank you.